For 5 o'clock has arrived. I will now officially call the Public Safety and License Committee meeting to order. Our first order of business is the approval of the minutes of the January 29, 2025 meeting. I have a motion. Is there a second? In 2 seconds. Any discussion? Motion passes. I'll let the clerk's office read the first item.
All right, so I believe we're going to go a little out of order today. I believe
Yes.
the first item we're going to do is 0114-25, communication sponsored by Alder Pete on behalf of the city clerk's office, submitting a new massage establishment application for Charles Long, DBA Douglas Ave Spa, located at 3417 Douglas Ave. Charles Long is the agent. So you're going to come on up.
Please come forward. I would ask for the attorney's office to swear you in, please.
We actually don't have to swear him
Okay.
in for this particular application.
Okay. Well, you're here because obviously you applied for a license. This is our opportunity to find out what your business plan is, your hours of operation, staff, proper parking, control of the premises, basically help make sure that you'll be a good neighbor, because this is our biggest opportunity to work with you and make sure that it's good for the community.
Yes, sir.
And I'll turn it over to the staff after you start. I'll let you start with your question. Tell us about your business plan.
Okay. The business plan for Douglas Avenue Spa is a little different than what's already established in the area. We will only have one room that will be with a door. That will be for female customers only. Male customers will be also assigned, but in a curtained area, no closed-off area. We do not disrobe. We will give garments, disposable garments, to the male patrons who come in. We have, it will be 3 cameras, one at the outside exit, facing the parking lot, 2 on the inside, 1 facing the inside of the establishment, 1 facing back out. I have had the opportunity to work with a detective from Racine PD, as a couple of spas had some incidents. And our camera system will be available to the Racine PD. They will have their own sign-in. If they need information, they don't have to contact us for anything.
What are your hours of operation?
That's going to be from 9 p.m. to 8 p.m., 9 a.m. to 8 p.m.
How many people will you have on staff?
Only the licensed massage therapist will be in there.
Okay. I'd like to have talked to the police department and the attorney's office next.
So I do have some information to provide to the community. In October 16th of 2024, there was a complaint that came into the city health department, saying that a massage establishment was operating at this specific location without a license. The health department personnel did go out there. She spoke with a massage therapist who was working at the time. She also observed a patron coming in to discuss the price of services. She then spoke with the therapist about not operating without a license. That person did contact a person whom she called the owner, which was Mr. Long at the time.
Yes.
He was in fact operating without a valid valid license at the time for the massage establishment. He spoke with the health department. The health department indicated that he should go to the city clerk's office to apply for a license. Have this license in front of you. As far as I can tell online, the premise is still open and operating even before the license. Additionally, we do have a police report from January of this year showing that the establishment was operating at that time, and there was also an incident that occurred at the premises that Sergeant English can give you more information.
There was a sexual assault that occurred earlier this year, with your Zeus?
Yeah.
Can you tell me about that a little bit?
Yes.
Can you tell me about that a little bit?
I actually was in China when that occurred. I was telephoned about it. Apparently, the person made an appointment by phone and came into the establishment, looked around, saw that nobody else was there. He then attacked the female. According to her, she was sexually assaulted. It wasn't a robbery, but we did, we got the information and turned that over. The problem is the Chinese people are traditionally afraid of law enforcement. primarily country noise. So she didn't want to report anything. I did call the police department, and an officer did respond. He tried his best to get the information, but the young lady just left. She didn't need to stay.
How do you expect, what are your plans to prevent that from happening in the future?
We actually, I can only hire, I have a security guard company. It's a private guy. He operates a little bit he did some work for Ascension Hospital. He is going to provide services on the Friday, Saturday, and Sunday nights. During the week, we're not that busy, and the camera system that we're gonna have, if we get approved, will be live. Anything that comes in, I automatically will see on my phone as well as he will see at home. He only lives about 2 minutes away.
I'm happy to ask some questions if there's, our attorney's office and the police department, have some further thoughts, we can touch back in. Chairman?
I'm sorry, I was,
No, can I?
yes.
Okay, thank you. Can you speak to, the current, I mean, in January, so it was just a month ago, that it was in operation. Can you speak to that at all?
Well, that's mostly my fault. We got the license for occupancy, and then when we put that in, I thought the license for massage was forthcoming. When the health department lady came, she informed me, no, you have to make it a separate application.
Have you ever had any other, massage establishments?
I had, 2 in Kenosha, 1 in Chicago, trying to get out of it, tell you the truth. Don't like either place. Racine's a little bit more welcoming area. Law enforcement has been real good to us. And, this will be the only other one. Well, I had, Main Street, and I just didn't like it.
Well, thank you for acknowledging that, Racine has a welcoming atmosphere. Yeah, so thank you for that. It sounds like you've had multiple establishments in the past, so I would assume that you'd be able to differentiate between getting an occupancy permit and then following the procedures to get a licensed massage establishment. So, to me, I feel like there's some negligence on your part of proper follow-through.
Yeah.
And you recognize this process that's in place is kind of like this check and safe measure for our community. And especially for massage establishments, just because they can be a front for other activities, so we have to get to know, to feel how things are going. And you're off on the wrong start right now, right? So that creates some hardship for me, because I can only base off of information that's come and then what is provided here. And as much as I love to celebrate those who are celebrating our community and want to put a business in it, and you're investing your funds to do this, and I'm assuming to then have a respectable business that provides you a livelihood to support, but I can't do that off the back of the safety of our community. So if you bypass measures, and the only measures in which we have, it causes a concern for me.
Understand.
And so I'm not sure how other committee members feel, but for that, if you've been now operating from October, November, December, January, we're here in February, about to be in March, without having that proper license in place, it triggers a red flag to me, what may become, and if it's harder once you have something for us to be able to retract it, but then there's usually wounds in our community then, and it's harder to heal those wounds that don't go away right away. So I just want to tell you the position I'm in. Right now, I'm not in favor of this application.
Well, I appreciate that, yeah.
Alderman Widener.
I had a question. I think either the attorney or the PD have said that not only was the premise not licensed, but also the masseuse was not licensed as well. Is that correct?
I don't have any information about whether the masseuse was licensed or not. All I have is a police report from the Racine Police Department that investigated an incident back in January where the massage therapist on the Main Street location was assaulted. Through the investigation, the investigator concluded and spoke with the victim, who identified that there were multiple assaults occurring both at the Douglas location and the Main Street location. So within the past 3 years, it looks like there are at least 4 attempted or sexual assaults occurring, 2 at the Douglas location, 2 at the Main Street location. The investigator then spoke with Mr. Long. He had indicated that he used to own the one on Main Street as well. He no longer owns it.
Yep.
And is now only operating the Douglas location. That's I don't know about the massage therapist.
Yeah, the therapist that was there that day is licensed. She actually is licensed in 2 states. She was transferring it over here to Wisconsin. She did receive her, transfer, I guess, how they do that. I had nothing to do with her.
From Illinois?
Actually from Illinois, and she also in, Ohio. So she had 2 licenses, and
She originally from China?
she is originally from China, farther than me.
Speaks English?
Uh,
So the therapist we have now, is she from China as well?
she is from China as well.
This is the same one that was back in
No,
January?
ma'am, no, that one left.
So, how do we find all these masseuses from China?
Well, they pretty much, they all communicate to each other. And when they want to move, or if they want to operate in a different area, they usually put it out on the internet that the Chinese use. And then they reach out. My wife is Chinese, so my wife finds them and says, okay, if you're licensed, yes, we can use you. If you're not, we can't use you.
I'd like to interject here. I understand that we're still missing some information. Our facts and findings are inconclusive at the moment, and because of that and the other concerns,
What are we missing? Sorry.
I'm not even at liberty in public to discuss everything we're missing. You could speak to after, but it's very important.
Are you aware that your, establishment is on the website, for patrons to go to and receive sexual favors?
We don't advertise anything about sexual favors.
There is a website that exists out there.
Not to my knowledge, I didn't put one up.
That has your establishment, by name, and then it has reviews from the patrons that go and receive sexual favors.
Yeah, I didn't know that. No, sexual favors is not allowed.
I move to deny the license.
Second?
I have a motion and a second. Any further discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
Thank you so much.
Good luck next time, sir.
Thank you.
Oh, he can come back in a year or so, right? He wants.
I don't know.
Okay.
I'll go back to China.
All right, thank you.
Our next item will be on page 3. This is 0143-25, communication sponsored by Alder Pete on behalf of the city clerk's office, submitting a new change of hours application for Harold's Chicken and Ice Bar LLC, doing business as Harold's Chicken and Ice Bar, located at 1521 Washington Ave, via Muhammad Agent, 3rd District. I do not believe the applicants are here yet.
Would the applicant come?
The applicants are not here yet. I know when I spoke to them earlier this week, I told them to come about 5:30, thinking we'd have the other items prior, so that's the,
Is there a motion to?
Hold on, there's people here to speak on this?
yeah.
Could we have them speak at this time?
Would it be appropriate to have them speak before the applicants here?
That would be up to the committee.
What do you want to do? Defer
I
to
think
later?
their time is valuable, so I would, allow them, I wish
Okay.
to hear them speak. on
Would the
this.
people who signed up to speak on Harold's Chicken please come up?
You want me to call
Yes,
them out?
please.
Come up first. Richard Kemper? You want to go ahead and sit right up here so you can speak?
Yes,
Okay,
go ahead, please.
my name's Dr. Richard Kemper. I'm a dentist. I live and have my office in the same block. This is the former Corner House restaurant. Been there for a long time. was never a bar, never stayed open that late. And, I was here, 6 months ago, or whenever it was, and that's when, this gentleman received his, liquor license for a restaurant, a chicken restaurant, and, the stipulation was that it closed at 10 o'clock. The main reason for that was we've had a lot of trouble in the uptown area after closing time with people milling around. And this has gone on for 10, 15 years. Every bar that has a lot of people, there was a big bar called Gerald's that started out very nice with food and things, and towards the end of it, it was people were just there at night. And then, especially in the summer, people hung around. And if you look at the geography of that neighborhood, there's the Owen Street is almost right next to it, and there's a lot of neighborhood. It's big parking lots where a lot of people go and cause trouble. I mean, they're young people having fun, but they're loud, and it's 2:30 in the morning. I don't think this is appropriate at all to change from what we compromised and made an attempt to allow him in with closing at 10 o'clock. Now, all of a sudden, it's 2:30. 2:30 is a bar, and a 2:30 bar is just what our neighborhood doesn't need. That neighborhood is starting to slowly come around. There's people here that are working hard with their businesses, and a bar that would close at 2:30 would be very detrimental to the uptown neighborhood.
Okay. So based on your observations, because you were here when the initial license was
Yes, I
issued,
was.
you spoke in favor of it, and you've seen some changes since then that are not positive.
Well, the operation that he has right now, he fixed up painted the building, looks nicer, and we haven't had problems, but he closes at 10 o'clock. Every time we've had a bar in that area that utilizes that parking lot, there's been problems after closing time, with people are just, big area, not real obvious to the police. If we had a police report of different, different bars that were there, they've caused a number of problems in the neighborhood. And it's late night closing is when the problems were. The shootings. My next door neighbor was shot outside his bar, just a year or two ago. And now he had, Mr. Cools.
Mm-hmm.
And if you remember that parking lot just down the street, from Mr. Cools, there's a parking lot down below by 13th Street. About 10 years ago, 3 people were shot. It all happens late at night. And that late night bar stuff is just what we don't need in Uptown. I'm all in favor of this chicken restaurant, but not till 2:30 in the morning. How much chicken are you gonna be selling those last couple of hours?
Okay.
To me, it seems like a front just to change from having a chicken restaurant, all of a sudden, we're gonna have a nightclub open till 2:30. And that's just what we were trying to avoid when we set up this, 10 o'clock
Yes, I recall.
closing time, if you remember.
Yeah, I recall. Okay. Thank you, sir. Very well put.
Thank you.
Thank you.
All right, next we have Christina Campbell.
I don't remember things as well as Dr. Kemper, so I wrote it down to read to you. My name is Christina. I'm the owner of the branch in Uptown Racine, located right next to, hi Pete, right
Hello.
next to Harold's Chicken. I've been a part of Uptown community for about 7 years now. I've always been passionate about growing the food culture, as well as supporting the arts and local businesses. When Malachi approached me with the idea of opening a restaurant, it was featuring multiple different franchises under one roof, which I was excited to see that vision come to Uptown. Food is something we want more of in the area, and I supported that business plan, fully. But from the start, Malachi made it very clear that he had no interest in obtaining a liquor license or selling alcohol to me. We talked about this, we've had long conversations about this. Over the years, since I've known him since he had Truth, Bar, so we discussed it a lot about how challenging liquor licensing can be, and he expressed that he wasn't, that's something that he definitely didn't want to deal with. And that's why I was okay with opening it as the restaurant. However, the focus has now shifted more and more towards liquor and less towards food, and that is not something I support, nor is it something that I would have ever backed in the beginning had I known where the plan was heading. In addition to speaking as a business owner of the branch, I am also here as the bid chairperson of Uptown, and I just wanted to let everyone know that all 7 of our board members are also against making this increase for the hours.
Okay. Thank you very much.
Next, we have Tim Hermes.
I'm Tim Hermes. I've lived in the Uptown for 45 years, about a block away from, the chicken place. In the past 15 years, the city hasn't licensed a bar in the Uptown that hasn't had a shooting or a killing or a drug bust or cost the city thousands of dollars in police involvement. About a year ago, there was a house on Owen Avenue shot right across from the chicken place. 9 times the plumbing was shot out of the house. They had all kinds of damage. The plumbing was leaking in the house. It cost thousands of dollars to repair. We've had 15 or 20 people shot or killed in the Uptown in the last 20 years. When you license these bars, it'd be nice to see if you license them as if they were living next door to you. The businesses in the Uptown are working hard to keep afloat. They don't need any more problems. And then there's the problem with all the litter and the trash and the broken bottles. And the bars, they're happy. They're making $1 million, but it costs the city taxpayers hundreds of thousands of dollars while this is going on. And I thank you for your time.
Thank you, sir, for your input.
Next, we have Ed Garza.
Good evening. My name is Ed Garza. I live in Junction, and I own a mixed commercial property. And I know the previous owner that wants to have their liquor license extended. I had 2 incidents that occurred on my property. First one, the patrons had broken my window, and I had to fix it, but the owner came to me and was going to give me a check, but his check bounced. So I had to cut down.
You're talking about the present owner?
Yes.
Okay.
So he finally paid it, but I want cash, no checks. Second instance, one of the patrons did burnt my building, set cigarettes inside a crack and started burning the building, and the fire trucks were announced.
And this has been since the current establishment opened, in the last 6 months or so?
No, this is prior, before.
Okay. Could you just kind of help us update
Okay.
on what
Usually you own
now?
the Truth Bar
Okay.
next door to me, and I'm right directly behind the corner house and the branch, where I can see the corner house from there.
Okay.
But, like these guys that spoke to before, it's just, the parking spaces will be all filled with cars back there. And all it is just bottles going around after the party's all done.
Okay.
And there's too many incidents going to happen down there, shootings.
You're still talking about in the present, in the last 6 months though, right? Okay.
But the current owner that wants to extend his license, McAllen,
Okay.
that's the guy.
Okay.
So I just want to let you know what's going on if you extend his license.
Okay. We appreciate it.
Thank you.
Thank you.
Next, we have Mario Martinez.
Hello, everyone. My name is Mario Martinez. And I just wanted to say that I'm very concerned about this particular situation. I'm somebody who has been in that area for a couple of years now. And one of the reasons, or I guess one of the things that got me a little bit interested in getting into that area is because I was with the Racine Revitalization Partnership for a while. And I saw the vision, I saw all the things that were being planned by this particular group when we were doing, I was on the board. And it seemed to me like a pretty exciting opportunity to develop the uptown area. And, you know, from what I can tell, with the differences that have already been made in that area, you can really see it in the types of neighbors that we have. The persons that I run into on a regular basis, it's just really different. So as we started to enhance our property there, it seemed like a lot of the neighbors wanted to do the same, right? And I've actually visited, my wife and I have actually gone to this establishment. We like the food. It seemed like a really nice place. You know, and I'm a business owner myself, so I can see that maybe there's more opportunities and being able to stay open longer and have the alcohol and that kind of thing, but I don't feel like this is something that's going to help the mission in the uptown area at all. I feel like it's going to probably pull us back. And the idea that there's this parking lot in the back behind the branch and stuff, it's almost hidden from traffic, so it's like a haven for people who want to do everything from get high, play their music, you know, do a lot of stupid things. I've seen it happen, so I know. But again, I'm somebody who has been in that area, and I'm really concerned, and I hope we really make the right decision here. And you know, I think it's just some things that I don't know that the police has time to be dealing with at that particular time. They do an awesome job, by the way. The time I've had to call the police, they came and they did an awesome job of getting people out of there. But you know, I think that's going to happen every weekend, in my opinion. But thank you all.
Thank you, sir.
Next, we have Ron Whitley.
Hello?
Good evening.
Good evening.
My name is Ronald Weekly, and my wife and I, we moved from Williams Bay to Uptown 13 years ago. We bought the Davies building, and it's commercial below and 4 apartments. I have 4 grandkids, and my grandkids come over. So far, in the past 3 years, there's been shootings behind 1518. There's been shootings at Mr. Cool's, now the Honors Bar. Rerun, a property we also own next door to him, was killed over New Year's with a bar. And I just think the amount of bars for the amount of people in Uptown, we have enough bars. I live there, so it's not just my business, but I live there. We have apartments. We're trying to help build Uptown up. We love Racine. And, you know, I'm active in the community. I go to the bid meetings. I'm an election official. And I'm concerned that we might be trying to overdo the amount of bars we have in the neighborhood. I'm retired Army and hotel and restaurant. I actually ran bars for 20 years. I ran one of the most exclusive bars in San Francisco, which is at the top of the Marriott. And believe it or not, whether it's a luxury bar or a corner bar, you have the same problem. Prostitution, drugs, fights, people consume alcohol, they do stupid things. And I just ask the board not to spend the hours. If they want to sell chicken, fine. I'll go and buy chicken from them. But if they want to sell liquor and bring that element in, again, I live there. I'm concerned for my grandkids. And that's all I have. Thank you.
Thank you, sir. Point well taken.
Last up to fight out is Victor Vargas.
Good evening, ladies and gentlemen.
Good evening.
I was born and raised on Owen Avenue, so I know the neighborhood. Was always the corner house there, now the previous owner is there, is trying to get and I'm all about having, you know, someone given a chance to have their business. But however, I live right in that parking lot. My parents' house is right there, and there's the parking lot. I see everything, day and night, every day. 2 weeks ago, I seen a guy carrying a gun running down at 10 o'clock at night in that parking lot. You know? And I think it was because he was intoxicated from another bar. Anyways, it's not important, but what I can see happening, the last month, the restaurant is getting very busy. I mean, there's more than 30 cars a night now compared to the wintertime. There was only a few people coming in and out. Now, I would think that if they were allowed to have a liquor license, there's gonna be more trouble there. I see everything. I'm looking in my binoculars, taking license plates down just in case something happens. And I know if there would be a liquor license, those people will be out there forever.
Okay.
No, and
Mr. Chairman, can you clarify for people that?
I'm
Yeah.
sure of them having
we've heard, thank you, we've heard several times about a liquor license. This is not about a liquor license, it's to extend the hours.
They have a liquor license.
They already have a liquor license.
Do, okay,
Yes.
well, then, the extending hour is what, from 10 o'clock to midnight or something like that?
2:30.
Yeah.
And that's where it might be getting a little confusing, because those are pretty much bar hours anyway.
Right.
And they already have liquor license,
Okay.
which gets into a totally different area in itself with the license.
Well,
we
extending
appreciate-
those hours would very, very much,
Okay,
cause a problem.
okay. Point well taken. Thank you, sir.
Thank you.
The agent is here
Yes,
now.
I was gonna say, would the agent for Harold's Chickens please come forward? Excuse me, I see the alderman for that district here. Did you want to say anything?
I believe the residents have, voiced their opinion, and so I'll let their voices speak for it.
Okay, thank you. Good evening. Appreciate your patience working with us, but as you may know, several people came in to speak on the issue, and I'm sure you remember that you're here, or know exactly why you're here, because you're requesting to change your hours from closing time at 10 o'clock to 2:30. Pretty much the same questions, and I would restate what we said 6 months ago. We have to make sure, protect the safety of the community, and find out what your operational plans are, your business plans, and make sure you're aware of how, if you change the hours, then if you're selling more food than, or more liquor than you are food, then you get into some licensing issues anyway. So could you tell us a little bit about your staff, how you're gonna maintain a parking lot, basically order, things of that nature? What are your plans to make it a safe area and protect, and take care of the concerns of your neighbors?
I feel like 6 months ago, it's like, our restaurant, like, really good about, like, serving food, and then, like, sell food, and then lots of stuff, and then, like, I feel like I wanna open more hours, because, like, I feel like Valentine's Day, and then, like, Super Bowl, or, like, holiday, we lose a lot of money, because like, we just only open, like, 2 until 10, it's not, a lot of people wanna ask me about, like, why you open so, why you close so early. And then, like, some people, they want, like, stay more late because they wanna watch sports or, like, Super Bowl or something. So I feel like I lose a lot of money, and then I wanna open, like breakfast, more breakfast, and then, like, brunch for girlies. Yeah, it's like...
Okay, I was just looking at your application. Before I ask the committee if they have any questions, can I turn it over to the attorney's office, or?
What are the current hours of operation?
current hours of operation are technically until midnight, but when the committee approved the license, it did specify that they have to close at 10 o'clock PM for any dine-in service. From 10 o'clock to midnight, they can have pickup orders only. So right now, they're asking for the hours to be extended to 2:30 each night. I would just point out that state law does limit the hours on weekdays, so on Sunday nights through Thursday nights, they're needed statutorily, that they can be open until 2 o'clock, and then Friday and Saturday nights, they can be open until 2:30. So if the committee were to approve, it would have to approve it with that amendment. It wouldn't be able to change it to 2:30 every night.
What time can they open?
They can open at 10 o'clock, right now, so it's opens at 10 a.m. to 10 p.m. for dine-in service. And then I believe Sergeant Neighbors may have some information regarding any nuisance issues or answer your questions after that.
So I guess there's another lounge that's gonna be opening up across the street. So just kind of concerned that you have two establishments selling liquor right across the street from each other. Cause issues. Not saying it will.
So there is a pending license application at 1518 Washington for another bar that has yet to come before the committee. It'll be at the next. That's the bar he's referencing.
So I'm ready to make a motion.
Okay, Alderman Capri, and then
I would like to ask a question before that. I remember you coming before us, when you were applying for the liquor license, and I just remember there was an adamancy about your statement about, we do not want to get in the bar business. And you really hyped up about bringing the food and the different ideas, and even the franchise that maybe was popular, like in Chicago, and bringing it over the border here in Racine. I would like you to speak on that a little bit, because it sounds like now with you, it's hard to come up with any other conclusion if you're trying to stay open till 2:30. Those are bar hours. So can you speak of when that mission or vision of yours changed? Because when you were here, I mean, you were very adamant about not wanting to be in the bar business.
Actually, it's not a business, just like, actually, we sell lots of food, and like, people like our food a lot, and then I feel like, people want more, stay more, because like they wanna like have fun, like talking with friends, and I feel, and sometimes they have like party, I mean like, the birthday, so like we, celebrate for birthday, girl, something, and then they ask me like, why you close so early? Because like we would like stay more and then like talking. They don't want to like go to another park because like it's all like crazy out there. So like they just want to like stay at our restaurant, have a good food, and then like just like talking and like watch sport or like show or something, like, you know, and then like
on the TV.
Yeah.
Yeah. So that defines a bar, really, just so you know. I mean, if people are hanging out, having fun, watching the TVs and enjoying food, whether it's sitting on a restaurant table, but it sounds like the TVs, which are in the portion of the bar aspects of it. So I'm not here to, you know, squash this vision in a sense in which you have. I just wanted to understand, because you were quite boisterous about what your business model was going to look like. And we talked about the corner house, and you had big shoes to fill, because that has been a staple in that part of the community for so long. And I remember just with your business plan and what you were gonna bring, saying you were gonna stay to that standard and keep that standard high, just like the corner house has been a true asset to the Racine community. The one thing that the corner house was not a bar, necessarily. It didn't mean it doesn't have that feature within it, but that's not how our community responded to the corner house. That's not, when we think of the corner house, we're not thinking of the bar aspect of the corner house. And so I remember that's what sold me when you presented your business plan to us, you know, how long ago. Can you speak to how has your business been going? Has it truly been showing signs of a lot of prosper? You're having people waiting to come in, or what is your business, looking like, and how has our community responded currently?
I feel like, 6 months ago, our restaurant like very good, it's like no problems. And the people like sometimes like, holiday or like Super Bowl, like last time, they waiting a lot for the wait list, and then they ask me, and then like we don't have no more space. And then like we close so early, and then they want like, stay more because like have fun there, like, you know, like the food good, and then like the people like, really nice. Yep, and then like, I'm thinking myself, oh, why I don't like open more like longer, so the people like can stay and like, I can like make more money, like, you know, because like, I feel like holidays like, is the day like I make a lot of money. Yeah.
Well, I can respect that, and I do respect that people are, talking about the quality of your food and really enjoying it. But you are speaking about those special occasions. You talked about the Super Bowl and special holiday. Oh, okay. Chairman?
Yes.
Okay. So, I just wanted to just make sure I'm understanding what you're saying. You know, having a place that houses functions and special events is a different type of business and establishment, a different business model. So I know you're coming before us just with an extension of hours, but to me, I feel like the whole business model has changed. So I would almost want to look at your vision of what your new business idea or business model is, because what I have before me on the previous application doesn't totally speak to all that special events and being open to house the different activities. It really was about being a restaurant with this addition of it's a different franchise bar and restaurant. So I have a little bit of a problem with that without seeing a brand new business model. But it sounds like if people are responding with this good food, you're doing something right. So I hope you just still, you know, focus on that, what people are truly responding to, and start developing yourself and give yourself that status of a true asset in our community like the Corner House is.
Yes, please.
Quick question, what is, your, ratio percentage of sales versus food versus alcohol?
In other words, are you selling more of food or alcohol? Breakdown.
75 food?
Are there any other yes.
I was gonna say, we have another, person for input, Malachi. Ms.
Yes. Please. Mr. Muhammad, please.
I don't think that, my wife's business has changed as much as a response to the community. If you go on Google right now, I think we're past 500 5-star reviews, thousands of impressions on Google. My wife might not be able to articulate, what it is that she's saying for we hear from customers. So, not to be open every day until 2 o'clock, 2:30, but we don't want to have to come in front of Amber every time and say, oh, come open for the Super Bowl, or, oh, can you do this? The flexibility, and I think we're missing the component that is we ask for 6 a.m. to 2 a.m. because of breakfast. People ask for breakfast. We can't open earlier for brunch and breakfast and stuff we want to do. So I think we are hinged on this later aspect of it and not just the parameters of what the statute has for a liquor license, because there's people that want to come from mimosas and brunch in the morning. My wife makes these very good breakfast bowls with grits in and stuff, but we're waiting at 10 o'clock to start, and people are like, oh, we want to come at 8, especially if it's getting warmer outside and things like that. And so we haven't had real issues. I walked in late. Maybe somebody talked about trash. That's not our doing. Eagle Disposal, which I just fixed with them this week, because they kept going to the corner house because the man sees on the paperwork they have the corner house, so they were actually getting Benny's trash more than they were coming to get ours, which is a technical area. They fixed it, and they came out for 2 trash pickups today and yesterday. And so we've been taking care of that. We got a newborn, so my wife has been at home. Her son was born in December. So, we're juggling 2 kids and under 2 and the restaurant. And so, our business hasn't changed for the community, at all. I think we have amazing people. We have stuck to only R&B and old school. We don't play the music that we promised you, and we have done that. And if you would have asked me 7 years ago when Alderman Cole told me that music changes people, I thought he was lying, but it do. So we have kept to that. You can thank our wonderful Alderwoman. She has seen it, have come in, and we sincerely focus on food and make sure people have amazing food. It's just those parameters of people. There was boxing stuff going on, and not everybody there for the boxing, but just the fact that some of these patrons that live in that community that come all the time, and like, we gotta, it's 9:50, you gotta go. What I was supposed to say, I'm like, they watching, yesterday when LeBron was playing, I was like, you can't stay. Yeah, I mean, they wanna see Luka, but you can't stay, you gotta go. And we hate to do that to people who spend hundreds of dollars per person in there to tell them like, oh man, I don't even have any flexibility, because if they come in here and you're in here, we're gonna get a strike. And so I think that is the where we find ourselves at, that it hasn't changed at all, except for we like the flexibility. We're not gonna be open every day to 2 o'clock in the morning. That's just a farce. It's not gonna happen. But to have to come and resubmit to the city clerk every time where things are going on, or if Mayweather decides to fight again, we would like to have that kind of stuff where somebody's birthday goes to 10:30 or 11 o'clock. We would like to be able to not to have to get up and leave and go bar hopping if they've enjoyed their birthday cake and their food, and we've been catered an event for them. That's all. That's pretty much what has been going on. I haven't seen any of you guys get any of this chicken yet, so I'm really concerned that.
You got some vegan chicken in there?
I told you I was gonna make it for you. I got us some more shrimp. I'm a vegan. I don't eat chicken, so I make it myself. We do have it gluten-free, and I make out of oyster mushrooms. It's very, very, very good. I don't do the cauliflower. I think that's gross, personally. But I think mushrooms, you can do anything with mushrooms. So I'm a Tabitha Brown baby, so I'm on my vegan kick for 3 years. So
Congrats.
thank you. But I will just share with that, and any other concern you might have, if I can articulate for my wife, I will. But we've been very adamant of staying in our perimeters, focusing on food, and just having that flexibility. So that's all I got.
All right, thank you. Alder Brilliant has one more question.
Yeah, so a couple things. One, the question is gonna be going to the attorney, but just a follow-up statement is, with respect, I can understand that you're sticking to your business plan and you're seeing something now come out of, now that you have a business, and the community is responding in a certain way. So if you are moving and shifting because the community is responding and it's making you see something differently, that is a different business plan, because you are now expanding into something else. So that is different. It doesn't mean that your heart hasn't shifted. Your heart may still be there and you want to be part of the community, but I know when I go to a certain, Italian restaurant, they close at 10. I can only get food up to a certain time, and I know I have to leave. Even if I'm enjoying myself, I can leave. I have to leave. There's people who need to go home. There's moms who have to go home to their children, and dads as well. So it is a business change. My question, though, is about the 6 a.m. If they wanted to open up, and have a breakfast offering, what was just mentioned, can you talk about that and what their options are?
So the request right now is to expand the hours from 10 a.m. to midnight, and the request is to change it to 6 a.m. to 2:30 a.m. So if this committee wanted to approve but amend that request, you could, for example, approve the change of hours to be 6 a.m. to 10 p.m. for dine-in, and then from 10 p.m. to midnight for carry-out only, as it currently. So that's an option.
Thank you for that, because I understood with what you said. You talked about some mimosas and certain offerings that you would like to bring forward, because I didn't understand that with that request, that was something you were looking for. So that's nothing I would do for you unless you're telling us that would be something that we would consider. What I don't want to see is going from your original application in which you brought to us. That's what sold me. But if you would have came to me and said, we want to open up a bar, and I would have said, no, the community is wounded over there. And I want you to be part of the healing. I don't want you to be part of the trauma that keeps opening that wound. And it sounds like what you have going on right now is working. It sounds like I'm not having anybody. People have come and they've talked about shooting. They've talked about trafficking. It can be picked up. But, once you have in the back of your establishment a shooting that ends in some death, it's hard to then go back and amend that right now, but you're still in a good place. I don't want you to tip on the other direction, and so we're a bit of like our own safety measure, if you will. Granted, it doesn't mean you come in with that intent, you know, I get a sense of a good person off of you, and I get a good sense that you want a successful business, and you want to provide something that people walk away from and celebrate. And I think that's what we're hearing from you. People are celebrating, you want them to celebrate longer. It feels good to be around celebration. But if you tell me that you would like to extend your hours to offer breakfast and brunch in those earlier hours, I'd be more apt to do that. And I'm willing to make a motion with an amendment for that, but I'm not willing to make an motion to go into the wee nights of the, you know, morning or after restaurant hours to be just a bar establishment, if that makes sense.
You good?
Well, I would want to hear if the applicant would be, I don't want to push this on you. I mean, I just heard, that was something that you had your mind for, to want to open up for breakfast with mimosas and stuff like that. I'm happy to make that amendment to your application. That's not what we have right now, but I'm willing to make that amendment if you wanted it. So that is a decision that you would make. You could even come back before us with that amendment, and we can just, either, no, I'm not gonna force a business plan on them. But I could defer this while you update your application, or I can make that amendment now and you can walk away and know exactly what's gonna be coming before.
I think whatever the decision is, what is parameters that we would like to see, if it's something that, you have come to such conclusion that you think that we cannot handle thousands of customers that we've done over 6 months with no issues, then that's the committee. But those are, we don't want to change what we put. We do want to offer, like, not at, between those hours, when we can. It's not going to be 6, probably 8 in the morning. We also don't want to just tell somebody at 10. But it's your decision to say that that's not what you want to do. What can you do?
Okay.
Just a procedural matter, if the committee were to amend those hours, I would highly recommend that you defer the item, have them amend the application and the business plan. That way you do have it in writing, makes it more clear down the road.
Okay.
What the parameters are.
And I would agree with that, and I'm so sorry, just to finish up my thought, I would agree with that. I would like it coming from your print, you know, not mine. You know, I'm not the business, right? But we have a responsibility, and it's that public safety. And there's a lot of historical knowledge that I bring to this seat, from being on public safety and having to wear those lenses and those goggles, you know, for a decade. And so, you know, it doesn't mean I'm the know-all, be-all, and I'm the only voice who has spoken so far, but I'm just telling you at least where I come from, just so there's a clear understanding. I'd rather, if you want your business hours to start at 6 a.m. or have the option to and open up at 8, I'd rather you put that in your application than me tell you, right? So, it's different. I can go ahead and be that restriction, but I could approve that ask.
So, you understand what she's saying. You're clear on the option. You can vote, we can vote. Let me finish, please. We can vote on what you put before us, your original application, or we can make a change in the hours, or you can come back and with it in writing, with changing it yourselves. I think, okay. Yes, you had a question.
If we deny this, do they have to wait a period of time before they can come back with an amended application?
There's no specific time period for this.
I move to deny.
Have a motion, is there a second?
Second.
Motion and a second, any further discussion?
I just have I am in favor of denying this particular application. My thoughts would have been along the deferment to make the process a little more smoother for them. All it is just an update on the hours. I don't know if by denying it, it's like filling out the whole application once again. Would that be true? So that's why I would have preferred a deferment for update, but I am ultimately in denial, or I would deny a request for the 2:30, but I would have liked to see a deferment to allow you to amend your hours. That would come before us, but.
I can withdraw my motion to deny, and we can defer this item if we want to go through all these again.
So what would you like to do?
My preference would be that we extend the hours in the morning, but not at night.
They're okay with that.
Which,
Well, that's sort of the holdup at the moment. I'm hearing from the applicant that they want it as presented.
I make a recommendation to the committee. If you deny this request, they could always resubmit another request since there's no time frame that prohibits them from doing that. So that might be the cleanest.
Okay. You understand, that? You guys clear on that part? Okay. All right, we have a motion and a second. Any,
Could you restate the motion? Because first I
Well,
moved to deny, and then I moved to defer, so.
the motion is to deny the application for Harold's Chicken as submitted, extending the hours from 6 a.m. to 2:30 p.m. with exceptions on a couple of days. 2:30. That was the original motion. I had a motion, a second, and discussion. All those in favor, please signify by saying aye.
Aye.
Opposed? Motion carries. But again, just point out, you could resubmit it with earlier hours with the same closing time, same closing conditions. So it's not a done deal unless you want it to be, I guess is the best way to say it.
that makes sense?
You could come back.
Are you understanding what was just said? So what
You could open at 6 and still have the same closing hours, or at any 6,
No.
7, what?
So at this point, the committee has voted to deny the extension of the hours.
Right.
The current hours are 10 a.m. to 10 p.m. for
Right.
dine-in, 10 p.m. to midnight for carry-out only. So that's what they can operate right now.
Right, that, nothing has changed, in other words. Everything's the same.
the clerk's office can explain what you would need to do if you want to send in a new request for some different hours.
We got it. Thank
You got it? Thank you.
Okay.
Thank you, guys.
Thank you. And congratulations on the new addition, by the way.
With that news, I will tell you that, unfortunately, the way it goes, we will probably be moving out of Uptown, to, Kenosha. I don't want that to be weighing on the community with that thing, but we do appreciate, everything that we've learned and Racine and all of the stuff, and all the stuff we learned. It has been a beautiful experience, and hope to, maybe in the future, serve you guys with, in the future. And with that, then I think that, but I love you guys, and thank you so much.
Thank you.
And we look forward to, in the future, serving you with something else. Thank you so much.
Thank you. And good luck again. Congratulations. And we go back to the beginning now.
We're gonna go back to page 1/016/424. Communication sponsored by Alder Widener and Alder Kelly requesting an update from the city administrator on the status of the police contract. The recommendation of the Finance and Personnel Committee on Monday, February 24th, 2024, to receive and file. I do believe this is what we have the PowerPoint for. If you guys give me 1 second, I'll get it set up.
Before we start, can I just say, on behalf of the staff that presented 2 days ago, the majority of the committee were at that meeting. Does the committee wish to see it all again?
No. Besides, we still have an notice that was sent out.
Well, that is the update. You asked for me to provide
Yeah, we have
an
the
update,
update.
and that is the update.
Okay. So,
The PowerPoint is the update?
Yeah.
So you don't have to do your spiel.
Yeah.
well, maybe just sort of summarize in
Summarize it.
general, a brief summary of it.
Well, Alderman Cole hasn't seen it, so I guess. we'll-
Okay.
Okay.
No word salad.
Okay, thank you.
Well, some members of the audience perhaps might not have. Just waiting to hear from Amber. Sure, I can start if we're ready to go. All right, so, members of the committee, thanks for the opportunity to come and report to you on the status of the collective bargaining negotiations between the city of Racine and the Racine Police Association. As Alder Widener had pointed out, Alderman Widener had pointed out, we did present to Finance and Personnel just a couple days ago on this, but not, everybody has had an opportunity to see this. So the city attorney has provided a PowerPoint that can take us through the story of how we got to the point that we are at. The key points here being that the Common Council did approve the tentative agreement on March 21st, 2023. RPA approved on March 16th, 2023. It is especially important to remember that we're actually talking about an agreement that has since concluded the period of time here, and in the course of that period of time, the city of Racine has delivered on all collective bargaining issues from the original negotiation. That includes all of the scheduled raises over a 3-year period, including the payment of 15% wage increases to members of RPA for the period of 2021 through 2024. There has been an interim hearing on this at WERC and also at the Dane County Circuit Court, which has remanded back to the Wisconsin WERC, Wisconsin Employment Relations Commission, which has yet to rule on this, although this was remanded to them 15 months ago. The standard for WERC to respond is actually supposed to be 15 days. So we have been waiting for that period of time. In the meantime, the city of Racine has delivered, as I said, on all of the collective bargaining items. No one has lost health insurance coverage in the course of this, and we remain ready to abide by the WERC decision when that decision is rendered. And so with that, I turn the floor over to the city attorney.
Thank you, Mr. Chairman. I will try to pass over some of the introductory things, but obviously collective bargaining between the employer and the employee, in this case, under Wisconsin statutes, section 11170. The city and the Racine Police Association first met to talk about an agreement that was expiring officially on December 31st, 2020. We're talking about that in December 9th and December 17th. We shortly realized among the bargaining teams that we weren't going to get anywhere. And let me say, I've been collective bargaining units in this city for my 19 years, dozens of them. And we've rarely had a new collective bargaining agreement that was in place before the old one expired. And what happens is the existing bargaining agreement continues in effect. So it's not as if there's not an agreement or a contract in effect. The existing agreement continues until the new one is bargained. But the parties were concerned they weren't going to reach an agreement quickly, so we contacted the Wisconsin Employment Relations Commission jointly and asked for a mediation. And the mediator came on January 21st, and mediated probably in this room, as I recall. And the issue was really about whether certain health insurance proposals are prohibited or other subjects of bargaining. And I briefly talked about this, and I will say there's 3 broad categories of collective bargaining, not only in Wisconsin, but generally across the United States, where collective bargaining is required, which we call a mandatory subject to bargaining, where it's permitted but not required, which is a permissive subject to bargaining,
and then where, collective bargaining agreements or collective bargaining is prohibited. So that's a prohibited or illegal subject to bargaining. Broadly required or mandatory subject to bargaining is wages, hours, and conditions of employment. Permissive subject to bargaining are generally within management rights of the employer, but the employer may, but is not required to collectively bargain. What we're talking about here is whether this is a prohibited subject to bargaining. Prohibited subjects of bargaining are subjects that are contrary to state or federal law. That is why they're prohibited. And I would note that there is a Wisconsin Court of Appeals decision that says where a subject of bargaining is illegal or forbidden, in other words, prohibited, there can be no negotiations regarding it, and neither party can insist on it being in the collective bargaining agreement. So if this is a prohibited subject of bargaining, it may not be in the agreement. We realized that we weren't going to come to an agreement among the parties. So the city petitioned for declaratory ruling, asking the Wisconsin Employment Relations Commission whether certain health insurance proposals constituted prohibited subjects of bargaining. Because it is our interpretation based on the plain language of the relevant subsection of the law, which is section 11170 sub 4 sub MC sub 6, and I'm going to talk about that in a little greater detail. A petition for declaratory ruling asks the Wisconsin Employment Relations Commission, please tell us what this section of the law means. That's all it is. And I would note, I mean, I know you received a correspondence from the Racine Police Association President, Investigator Cooper, and I've had the opportunity to see it. And let me say that what he lists in here is a perfect example of why there would be this procedure to go ask the Wisconsin Employment Relations Commission what the law means. I've heard this, what he put in here from the Wisconsin Police Association attorneys. We clearly have a disagreement. That is why there's a process for a declaratory ruling request. Or frankly, that's why there are courts. If people have a disagreement, you go ask the court, please settle our disagreement for us. That's why it exists. And I will comment in some ways on what's actually the contents of that letter. So in the prior contract, and this, frankly, this sort of language has been in contracts. I've looked at police association contracts back for 30 or so years. The health insurance plan design and premium contributions have been laid out in the contract for active employees, for retirees spouses, and for retirees dependents. You may recall that when Act 10 and Act 32 were passed, they actually changed these to prohibited subjects of bargaining. And Act 34 attempts to clarify, or does clarify what that means. But these provisions were in the contracts for years and years before the law changed to make them prohibited. And they stuck around for a couple more contract rounds. I understand that's true, but the fact that they were in the contract doesn't necessarily mean they were lawfully in the contract or should continue in the contract. So this is the contract that existed from 2018 to 2020. Of course, it had everything else that goes in collective bargaining agreements, not just this. When we were bargaining the issues over health insurance with RPA, RPA said, in part, we want to change the premium contribution from what was 10% to 7.5%, but otherwise we want all the language in the contract, as Article 10, that relates to health insurance to stay in the contracts. Our response was, we're good with the 7.5%. Frankly, that's what the Common Council and the Finance and Personnel Committee, who is the one that directs collective bargaining, with the city administrator as the lead, that's what they told us to do. And we agreed to that, but we said, no, the other language that was in Article 10 about health insurance plan design and health insurance for retirees and spouses and dependents should be removed from the contract because those are prohibited subjects of bargaining. So as I said, if they're prohibited, it's illegal under the law.
And then upon removing the language about insurance would go in what we have called, throughout this process, a legally appropriate document. So, as you know, we have an employee handbook. That employee handbook has existed for years, and it lays out the health insurance program for non-represented employees because we had it in contract before that. But that's what we said, is it should go then in the employee handbook to talk about what the health insurance plan is. This is what the law said after 2011 Johnson Act 32 was passed. So this was the law in existence in 2021 when we were negotiating the contract with police and fire. And it's since changed a little bit, but the basic substance of this law is still there. It says for public safety employees, these are prohibited subject to bargaining. The employer is prohibited from bargaining collectively with the collective bargaining unit containing public safety employees, police and fire, prohibited from bargaining all costs and payments associated with health care coverage plans and the design and selection of health care coverage plans by the employer for public safety employees, and the impact of such costs and payments and the design and selection of the health care coverage plan on wage hours and conditions of employment. So the only thing that was not a prohibited subject, in other words, what was a permitted subject, is the employee premium contribution. At that time, that's what the law says. Everything else is permitted. And in fact, I have this a little more emphasized, so prohibited except for the employee contribution. Every other thing about health insurance was prohibited under the plain language, the clear language of the law.
Yeah, can you clarify something for me?
Yeah.
This was as of 2011, correct?
Yes.
So in any contracts that were negotiated after 2011, that insurance language was in the contract, correct?
For the next couple of rounds, it was.
It was. So what's different about 2021 than there was the previous contract?
Well, you may recall that the Common Council made a lot of changes to the health insurance plan broadly in 2020, effective in 2021. That sort of triggered this. And this was, well, you might have heard about it, even though you weren't on the council. That's what triggered this direction that we had. That the question was, look, we probably should not have included in contracts before. And, you know, certainly nobody's going back and saying, well, we need to reverse that or change things or take things, or none of that kind of way. But moving forward, it shouldn't be in the contract.
But Scott, if this is what's disputed, and it's been in the contracts previous, why couldn't it be in the contract, this contract, until such ruling comes from a WERC, which knows when that'll be?
I could make the equal argument to say, why shouldn't it be taken out of the contract until we get the ruling from the WERC? It's just as strong an argument.
I have a question. You said this was from when?
This was the law that started in 2011, but it was in existence in 2021 when we were bargaining this 2021 through 2024 contract. I haven't gotten to the recent changes.
Proceed.
So again, and I realize I'm saying this over and over, but I think it's important. The only thing that was permitted at that time was bargaining over the health insurance premium contribution, which we absolutely did. Was prohibited to bargain over all costs and payments associated, so deductibles and maximum pockets and things like that, co-pays, that kind of thing. Can't bargain over the design and selection of health coverage plans, what it's going to cover, can't bargain over there. And by the way, federal law, this was after the Affordable Care Act was passed, so there's a lot of federal law that was just required. Nobody ever talked about taking that kind of stuff out, of course. And then sort of the impact. So we talked about the impact of managerial decisions, management decisions that might affect wages, hours, and conditions of employment, which are mandatory subjects. But we were told under the law we were prohibited to bargain over the impact of cost of payments on these other mandatory. So this was all prohibited. WRC in July 22, issued its decision that said, city, we agree, the RPA is prohibited from bargaining with the city over the disputed proposals at issue. So you recall, we agreed on premium share, and we disagreed. We disputed whether anything else should go in the contract. And the Wisconsin Employment Relations Commission agreed with the city's position. The RPA is prohibited from bargaining with the city over retiree health benefits, health insurance benefits. But the WRC also did, and this is what sort of caused a problem for everybody, said that the city has the discretion. It interpreted the law as saying municipal employers aren't even required to provide health insurance for their public safety employees. We never argued that. The city never argued that was the case, but WERC said that. WRC immediately appealed. By the way, there's a similar track here, Local 321, the firefighters. Today we're talking about police. And the way it works is when there's an appeal of a decision by a regulatory agency in Wisconsin, that appeal goes to the Dane County Circuit Court rather than Racine County. So they appealed and it went to Dane County. The WPPAs, so the Wisconsin Professional Police Association, on behalf of RPA, just challenged the part of the WRC decision about whether the city had discretion to determine whether it'll even have health insurance. And we referred to that as the existence issue. It's been referred to by both sides as the existence issue. Whether there exists a requirement to provide health insurance to public safety employees. That's the only thing that WPPA argued about the WERC's decision. In any event, it went to the Dane County Court, and there was briefing and court hearings and things like that I will talk about. The parties continued to meet, held a mediation with the WERC mediator. A couple more mediations, and then finally we came to an agreement after one really long day of bargaining. I'm sure a lot of the police officers in attendance here were part of that bargaining. We came to what's called a tentative agreement. That is an agreement between the negotiating teams that everybody initialed off on for both sides. And I will tell you that there's a principle in the law that says if you have a writing that is signed by a party, initialing is a signature, that's a contract. So we had an agreement between the negotiating teams, of course, subject to ratification by the RPA membership and approval by the Common Council.
Scott, did that tentative agreement have the language regarding the retiree insurance in the contract or not?
It had it out of the contract.
It was out of the contract. On March 21st, 2023?
Yes. The tentative agreement was presented to the Common Council. I think one of my next slides actually has the specific language on the tentative agreement. So, and then the Common Council approved the agreement. So frankly, at that moment, we had a contract. It wasn't a signed collective bargaining agreement, but both sides had agreed. This is what the tentative agreement said, and I've got some bolding in a moment that'll give it in more detail. But the members will pay 7.5% health insurance premium, as both sides agreed. The tentative agreement, again, initialed by both sides and presented to the council and RPA membership, but other language in Article 10, insurance, regarding health insurance plan, shall be removed from the collective bargaining agreement and placed into a legally appropriate document, the handbook in this case. So that's what that said. And then it said, going on, that the language that was determined to be prohibited by WERC, as I said, WERC said this is prohibited, shall be removed from the collective bargaining agreement with the understanding that if the WERC ruling is amended or modified by virtue of litigation or legislation, the parties agreed to be bound by the ultimate outcome, and that's the words that were used, ultimate outcome of the litigation, or any future legislation that addresses the legal status of employee, and I'm emphasizing the word employee, employee health insurance for active public safety employees. That's the language that both sides agreed to. The city then, so this is in March of 2023, after the Common Council approved it, then the city went about fulfilling its obligations under the collective bargaining agreement. So this was a 2021 to 2024 contract that was approved in March of 2023. In April and May of 2024, all payments that were required for back pay and other payments to any of the RPA members were made. It was approximately $4.5 million that was paid to RPA members in April or May of 2023. So the wage increases were 15% over 4 years. 4-year contract, 4%, 4% 1 year, 4% the next year, 4% the third year, and then 3% in 2024. So the 2021 payment was made, the 2022 payment was made, the 2023 payment through March, April, May of 2023 was made, and then of course that 12% increase was continued to be paid through 2023. $2,000 retention bonuses were paid out to RPA employees. There was the new 3% resident pay incentive, the Common Council approved. By agreement between the parties, this was requested by Racine Police Association negotiators that it only applied to new RPA members. As agreed, the impermissible language that was determined to be prohibited was moved into the legally appropriate document and out of the contract. There were sick leave payouts. You recall the Common Council has been trying to reduce the sick leave legacy liability. Sick leave payouts were made. Martin Luther King Jr. Day was added as a paid holiday. 320 hours of paid parental leave were made available to RPA employees. There were some other changes in the contract that were all implemented. So that was March, April, May of 2023. In October of 2023, Dane County issued its decision on the appeal of the WERC decision. It said the issue of whether or not municipalities are even required to provide health insurance was never raised by any of the parties. So agreed, the city of Racine, and then nobody else, argued municipalities don't have to provide health insurance. Okay? Nobody I've ever heard of has said we don't have to provide health insurance for employees. So that was never raised. And the court said the law, and this is again the same section that we've been talking about, 11170 sub 4 sub MC sub 6, implicitly requires that municipal employers offer public safety employees a health insurance plan. Vacated the WERC's decision, in other words, said the WERC's decision no longer is valid, and then remanded the case back to the WERC. So the supervising court here said, WERC, you are required to go rewrite the decision that is consistent with what the Dane County Court's order said. So the Dane County Circuit Court case isn't proceeding at this moment. The litigation isn't done because we're still waiting for the WERC to make a decision. This is October of 2023. There were some other actions, some motions that were made requesting certain things that were brought by the Racine Police Association, actually Wisconsin Professional Police Association, asked the Dane County Court for some clarification on things. The Dane County Court reaffirmed its order in, I believe it was February of 2024. So we've been waiting now since February of 2024 for the WERC to reissue the decision that Dane County Court ordered it to.
Can you reiterate what the question is before the WERC?
Whether or not these health insurance provisions are prohibited subjects of bargaining. That's the issue that remains. And again, I understand there's some dispute that says we've reached the ultimate outcome. But we haven't reached the ultimate outcome, because when the WRC finishes rewriting its decision, it's going to have to go back to the Dane County Court. It will have to report back to the Dane County Court. And presumably, if there's somebody, if WRC issues a decision that WPPA doesn't like, it can appeal further.
So Scott, because that language that was removed from the contract is now in the employee manual, does that apply to public safety employees?
Yes.
And-
There's a specific section for retired public safety employees. So that broad health insurance plan for employees, there's one health insurance plan for employees. But the Common Council, at the end of 2023, approved a policy for retired public safety employees that actually keeps public safety employees on the city's plan after retirement. It's a little different for fire than it is for police, just because of the evolution of those two units. But it's there, and then it was put in the handbook by the Common Council, I think in March of 2024, something like that, about a year ago. So it's been in place for about 15 or 16 years.
Does that language in the employee manual have the same weight that it would have if it was in the contract?
It's a fair point to make that the Common Council, because the Common Council passed that by resolution, the Common Council could change anything, frankly, that's a policy, as long as it wasn't illegal, change any policy or anything in the handbook. So yeah, it's a fair point to make that the Common Council at some point in the future could decide that it wanted to make a change to the policies that are part of that handbook.
But isn't it also true that they could make that change in a collective bargaining agreement at some point in the future?
The Common Council could refuse to agree to something that's collectively bargained. That is true. And then it wouldn't go in that collective bargaining agreement unless WRC or court told us it had to.
So then the other issue is, when you're bargaining as an existing employee for benefits that you would continue to receive once you're retired, isn't that still an employee benefit, even though you're bargaining for those benefits for once you're retired?
I don't think so, and I understand this is a fine point, but you're bargaining for benefits, employment benefits for when you're employed. Since we believe the clear, plain language of the law says, or means that bargaining for retired employees or people who retire at some point is prohibited, is illegal. You cannot bargain today for benefits that will kick in later.
So why don't the municipalities across the state of Wisconsin have that in their contract?
Some do, some don't.
I actually did a lot of research over the weekend and pulled probably 10 different contracts all over the state of Wisconsin. They all seem to have that language in there, and those are a lot of current contracts that run through 25.
I have 3 current contracts with police associations in the state that say something different. Onalaska does not include retiree coverage.
Where?
Onalaska, it's a city in La Crosse County. The city of Fond du Lac Professional Police Association contract does not include health insurance for retirees. And I thought it was interesting, frankly, the Oshkosh Professional Police Association contract is going to hold up. This half a page here is the entirety of health insurance in the Oshkosh Professional Police Association contract. All but one line of it is how much is paid for premium share, and it's 12% if employees complete a health risk assessment and 15% if employees do not complete a health risk assessment. And this one first sentence here says, the employer shall provide health coverage. There's literally nothing else in the contract about it. So contracts are different in different parts of the state. I understand that no other municipality has asked our WRC to decide, but there are differences in contracts.
I have another question when you're done.
Great.
Oh, thank you. So, Scott, from my understanding, Act 34 was passed to clarify the intent of provisions of Act, 10 and 32.
That's
Do I understand that? Okay. And the legislature described it as a restatement of the current law.
Right.
So what I'm trying to understand is there are Wisconsin municipalities that have the standard healthcare provisions in the police contracts, even though you stated some that do not. Can you help me understand why Racine is taking the position and, what are we to gain, I guess, out of the position we're taking? And there are other municipalities who clearly have it in the contract. So I want to understand that perspective.
Well, I think, first of all, we're doing this because it's what we were directed to do. Again, by the Finance and Personnel Committee that directs collective bargaining. Frankly, I think there's a number of reasons, and I wish the finance director could be here to talk about the costs of employee and retiree health care. And frankly, I have heard her say on a number of occasions that the most expensive group of retirees is those between age 50 or 52 when police officers and firefighters retire to those that are the age of 65. Most non-represented employees retire after 55 or older than that. Some actually retire after they're 65. But it's a really expensive group. And one of the issues is the premium share that would be paid by retired employees. And one of the provisions that the RPA insists should be in the contract is the premium share to be paid by retired employees. So that's an issue. It's a big chunk of the financial calculus when it comes to healthcare plans. There's another reason, I think, is the law seems very clear to me. And I understand there are other people that say the law seems like it's something else. But I read the law, I read the words in the law, and I say this is what I think the law means. And honestly, I was thinking about this, and I apologize, I'm going to quote from something else. Antonin Scalia, who's a United States Supreme Court Justice, probably the greatest conservative legal thinker in this country's history, said, "We are not governed by the drafter's intent. We are governed by laws. We do not use extrinsic factors when determining what a law means." He would say, you look to the words of the statute, and that's what it means. You don't look anywhere else. And I think that's an important consideration. So let me just talk about Act 34, because I think it is important to talk about it. And I agree, the legislature said when it passed Act 34, we're saying this is what we always meant. Okay? So, again, a restatement of law, so we've talked about that. And Act 34 only relates to the statute we've been talking about, Section 11170 sub 4 sub FC sub 6. It only relates to that, this existence issue. And what the law added is these two areas that are bolded and underlined. Exactly everything else is exactly what existed before Act 34 was passed. So it added as whether or not to provide health coverage as not the prohibited subject of bargaining. In other words, whether or not to provide health insurance cannot be prohibited. That's illegal. You have to bargain over it. And also added, for the purposes of this subdivisional loan, so just this section we've been talking about, design, because it talks about healthcare design does not include the decision as to who is covered by a health coverage plan selected by the municipal employer. So that is not prohibited. And frankly, it's saying that when we're looking at what is prohibited, design doesn't include who is covered. I understand this is a point of contention, so I'm going to talk about it. So right now, the law specifically permits bargaining over health insurance premium contribution, whether or not health coverage is provided for public safety employees by the employer. And I will emphasize, we have used the word employee because that's what the law says. Okay? Whether or not health care coverage is provided for public safety employees by the employer. And which public safety employees are covered by a municipal employer's health care plan. And I'm just going to go back because I understand, and I have had many conversations with RPA, WPPA's attorneys. That goes to this last question. Who is covered by a health care coverage plan selected by the municipal employer? And you can see, and I'll talk about this again, this statute defines the municipal employer for public safety employees. Municipal employer here has to include public safety employees. Someone who is retired is not an employee. And I understand that Investigator Cooper's letter said we've never talked about retirees, but we want the old language back in the contract that has language about retirees. This is what's prohibited. All costs and payments, this is the same stuff that's prohibited. All costs and payments associated with health coverage plans, except of course premium share, the design and selection of health coverage plan, and the impact of such costs and payments on mandatory subjects. The law has never allowed bargaining over health insurance to be provided to former employees, retirees, because they are not employees. If the legislature wanted to include health insurance for retirees in Act 34, it had the ability, and it certainly could have. Act 34, when it went through the legislative process, both the Senate and the Assembly proposed amendments to the bills that ended up being the act, that would have specifically added retirees back in. This is the language that was proposed. For the purposes of design, of the subdivision, design does not include coverage of current employees and their dependents, including coverage upon an employee's retirement, death, or disability by a health care coverage plan. So this was proposed, and I think it was in the Senate, it was voted down. I may have that backwards. In the Assembly it was withdrawn, or it may have been in the Assembly it was voted down, in the Senate it was withdrawn. But this was proposed, and this was rejected by the legislature to specifically add retirement, post-retire benefits in to health care. And this is what was included. It does not include the decision as to who is covered by a municipal coverage plan selected by the municipal. So that's what the law says. And I will go back to a question that Alderman Widener asked me is, what difference does it make? I will say, you and I have talked. I hate talking about these things publicly. I think it's really inappropriate. You've asked me to come here and talk about it.
And I appreciate
I've been the city attorney, or in the city attorney's office for 19 years. You will never find one moment where there was a litigation involving the city that I publicly commented on that litigation. There's a litigation going on right now. These are my fellow employees. I don't like being one of the faces of a dispute. I don't like it. I'm not interested in doing it. But the Common Council, when they appointed me as city attorney, told me, you have to advise us on what the law says, and that's what I'm doing. So that's what I'm doing. The letter from Investigator Cooper has some things that I've heard from their attorneys, but I disagree with. For instance, saying benefits that are bargained for during the collective bargaining process cannot be taken away or changed once inside the valid or signed contract. We know that's not true because benefits change all the time. Every non-public safety union in this state had their collective bargaining rights taken away. The law changed. The only we don't have any of these unions left in the city of Racine. We had some that lingered for a while, but the only thing that non-public safety unions are allowed to bargain, and transit is in a different category altogether, is total base wages. That's the only thing other unions are allowed. Clearly, if the law changes, the law... Many of you know, I'm a retired United States Air Force officer. I have benefits from the United States based upon my service as an Air Force officer, and they have changed since I've been retired. Now, I wasn't a union employee. There are no union employees in the military, but my benefits have changed since I've been retired. That happens sometimes. I don't like it. That happens. Investigator Cooper says, the healthcare language should revert into the contract per the mutually agreed upon, written into the tentative agreement because it's no longer prohibited. That's not true. The law still says that that bargaining for health insurance post-retirement is prohibited. Bargaining for the amount that a retired person would pay in premium share is not it's part of the category that says is prohibited. You bargain for active employees. That's what the statute says. So here's the entirety of the statute. Except for whether or not to provide health care coverage, nobody's arguing about that. The city has a health insurance plan, nobody's arguing about it. And the employee premium contribution. It says employee premium contribution. It doesn't say post-retirement premium contribution. So those are the only things that are not prohibited. All costs and payments associated with healthcare plans, the design and selection of healthcare coverage by the municipal employer for public safety employees, and the impact of such and so on. And again, it says that design does not include the decision as to who is covered by the municipal employer. And right here in the statute, we have the phrase, the municipal employer for public safety employees. That's what the municipal employer is. Investigator Cooper quotes a letter from Senator Wangard, and Investigator Cooper quotes the letter accurately, but the letter does not quote the law accurately. The letter says, and I'm reading here, is in the middle of the second paragraph of Investigator Cooper's letter. Act 34 states the existence of healthcare coverage and who is covered by that coverage is negotiable by public safety employees, right? The problem I have is with the word by, negotiable by public safety employees. If we look here in the middle, it says it's for public safety employees. It doesn't say bargain by public safety employees. It says bargain for public safety employees. And that is a significant difference. You and I have talked about words mean things, and we talked about whether shall, must, may, should. What do those mean? The legislature is assumed, when we interpret statutes, we assume the legislature understands everything that's else in the statutes and understands why it's using specific words. And it intentionally uses specific words because they have specific meanings. There is nothing in this that talks about anything other than public safety employees. There's nothing that talks about post-retirement. There's nothing that talks about any other particular group. That's what the law says. Again, he says Racine is the only municipality that's attempted to remove the language from the contract. I mean, I know that's not true. I've come up with 3 in a day. There's, 190 cities in the state and 400 odd villages and 1,000 towns. I mean, a lot of them probably don't have police departments, but a lot of them do. And they all certainly have collective bargaining agreements with their police departments. So I don't think either of us can say there are X number of contracts that contain retired employee provision or X number that don't. But it's clear that some do and some don't. He also says, once the healthcare language is returned to the tentative agreement, it can be signed and approved into a contract, so the 2021 through 2024 contract. Let me say, I've heard Investigator Cooper say, and I've heard others say, well, it's in the contract, that's a practice, that's a past practice, therefore you can't change that, it's got to be in there. So if, in fact, this language went into the 2021 through 2024 contract, there could be an argument made, well, you put it in that contract, what do you mean now it can't go in the next contract? It makes just as much sense to say, we all agreed we're going to wait for the ultimate outcome of this WERC, WPPA litigation, so let's put in the language that says there will be health insurance, there will be a 7.5 premium share, and when we get the final decision from WERC, subject to any potential appeals, that will go in the contract. It makes just as much sense to sign off on a contract that says that, pending the decision, than it would be to put all that, what we truly believe the law says is prohibited language. And again, he's right that, and I talked about this, that the City of Racine, the Common Council has changed eligibility for post-retirement benefits for non-rep employees by policy. If you're hired as a non-represented employee after January 1st, 2021, can't get post-retirement benefits of any kind. And in fact, along the way, the law has changed. It used to be 40 years ago, if you retired, you had health insurance for the rest of your life. And then at some point it changed to, in fact, it was 2007 to 2010, depending on the employee group, that once you retire, you get it till you're Medicare eligible. And once you're Medicare eligible, you don't get to be on the city's insurance plan anymore. So it has changed. It is modified over the years. And it's absolutely correct. The Common Council could decide it was a business decision it wanted to change and decide what to do. But for now, it's an important point to make.
Just one other question.
Attorney Letney, I do respect that, you sitting here before us and before finance, you haven't been in this position in your years to have to publicly have to go into this level of detail. I think this time calls for it. I'm not sure if, in the history, if we've had our police officers without a contract for 5 years and then having it come before the council so many times making statements. I know I've been in a position of not understanding, as somebody who's elected and being a representative for the city, it's hard for me to publicly then either support the position of the city because I didn't know the position of the city. And so, and I think the only voice that has been heard has been the police, and if we don't offer another understanding of it, right, you only give us one side to go, one direction to go. And, with respect for your professional career, you have a perspective with a certain interpretation that may vary from the rest of us. But there's certain things that it just keeps clicking in my head is that you've said it not only now, but you've said it on the floor for other things, is that it's a legal opinion. And so, I don't want to discredit your legal opinion, because what we're seeing is there's other Wisconsin municipalities that are maintaining a standard health care provision in their police contracts. So that means their interpretation of what's going is definitely different than what your interpretation is. There's different interpretations across Wisconsin. And I'm hoping that's a fair statement. What did you want to say?
No, I was going to say, I don't know, because I haven't talked to those other municipal attorneys, if they have a different interpretation or are in a far different position financially than the city of Racine is. And we know that literally every other city or village in the state is in a different position with regard to legacy benefit costs for retirees. We've seen that data. It's unquestionable. They just haven't proceeded this way.
Gotcha.
And I just wanna say Brookfield, the city of Brookfield has said in their contract, we're waiting to see what happens with this Racine case, and then we're gonna do whatever happens.
I'm not sure if this is the type of thing I want Racine to be a leader on, quite honestly. And, you know, when we make certain, promises at the get-go to our employees, you're gonna come in and, you know, this is what we're gonna offer you. You know, I think we have this obligation, you know, this is my opinion, and if we can't afford it, then maybe the people who are making that decisions to change are just really uninformed, and they don't have enough of the wisdom to be in a position to make certain decisions. I mean, granted, we can't predict, there's no crystal ball. But, you know, I've seen in these past time coming back on the council, I'm gonna make this bold statement, but there's been frivolous spending that's just going on without any thoughts of how that's gonna impact the future. Are we gonna be able to uphold our contracts? You know, when other municipalities are interpreting these same laws differently and maintaining a more comprehensive negotiation practice, but Racine chooses to interpret these restrictions more strictly than other municipalities, it's not, I don't believe, because Act 34 compels this approach. You said, because I asked, why are we taking this position when there's others that aren't, even if there are others that are, but why are we? And you said it's by the directives of the Finance and Personnel Committee. And then you stated that this is an expensive group, but by the age of 50 or 52, whatever it was, well, it rightfully should be, because they're the ones, I would assume, that compared to our first, second, and third floor here, they're showing up when people's heads are getting shot off. You know, they have there's a lot more risk they're taking on their job than showing up to sit on an office desk. And I think that's the understanding, and I think they understand that's a risk that they're taking when they choose this career path. But with that, there comes a certain level of consequences. I'm sorry, I didn't know that you served, but my brother, being a veteran too, I'm a little out of my language wheelhouse here, but when he relieved himself of service and retired, he had to take a PTSD evaluation, and he hit everything on the high marks, everything, and I found out a little bit about this because he got a service dog, you know, as simple as that. But when I started to do a little more research, when he talked about his PTSD evaluation, you know, I started to find out what he did during his term in the Navy. And I don't hear these officers talking, at least when I'm out in the community or I run and engage, are talking about the stresses of the job. But they ultimately are there because they become the ones we're calling for 911 or, so they don't wear that every day, but it's an understanding, and that's why it is part of a contract. And so, my belief is effective governance means making decisions, decisive decisions with the information we have at hand right now, while building like a flexibility in for future changes. And not using potential future developments as justification for inaction. And I feel that's what we are doing, is that we're waiting for WERC, but yet we have, I believe we have the language to move forward. Granted, they may come up with something different. Well, let's move forward with the language we have now. We don't need them to clarify anything at this point. They may come when that information does come. We're sitting and waiting. When it does come, let's act then, because there is a negotiation process. We can come back and talk about making those changes at that time. But to drag it out, I think we're busting up our morale. We're losing the option to recruit, and I think it's completely harming our relationship. We're not looking like a cohesive city. All of our departments are starting to fall apart. So I say, let's act on what's before us today. WERC comes before us as something else, come back at the table at that time. But I just don't think we do much service by sitting here and holding and delaying for additional confirmation what already has been legislatively and judicially established. I just think, acting now is the right position to be at, so we can start building morale and recruiting, good candidates.
Yes. Alder Perez asked first.
Oh, okay.
Alder Perez.
City Attorney. But, so my question to you, sir, is, you've often stated that the council, has the authority to change things. I've been on council for over a decade now, and I remember putting things on the handbook, which I thought was wrong, because the handbook could be changed at any time when we decide to change it. And we can delete things from there. So, looking at the conditions of employees or retired employees, we can void that at any time if the council decides to do that. What prohibits the council from ordering or legislating, since we're the legislative body, that this contract gets settled immediately, the complaint be withdrawn, and that it complies with this? And I'm saying that because 2 years ago, when the mayor ran for office, he had posted a picture of him saying, "I signed the police contract," which was a lie. Okay? If he was willing to do that, it's on his Facebook page. I can pull it up if you'd like. It's still there. What prohibits us from telling you, as the city attorney, to withdraw the complaint, settle this immediately, and move forward?
Yes, please.
Well, the current litigation posture exists because WPPA, RPA, appealed the decision of the WERC. So right now, it's being litigated because it was their, so the city doesn't have one.
But we have spent close to $1 million.
Now, those numbers are, I'm sorry, Alder, I have to object. It's not true. I don't know where people came up with those numbers. I've gone through I have a spreadsheet of invoices. Maybe for other things, there was a lot of money spent, but not for this. So anybody that says it's $1 million is mistaken. Understands. We spent for Racine Police Association negotiations in 2021 and 2022, $71,076, $71,076.50. And when RPA appealed the decision for Dane County Court, which was combined with the local 321 firefighters decision, that's $147,722. So that's $218,000. I understand it's $218,000, not $1 million.
Okay. Thank you. Nonetheless, isn't that something that we could have negated along and used some of that money maybe? I know it's different categories, but to settle some of this, is it within our venue as the city council to do something to the effect of ordering the signature of the contract, continuing with the lawsuit but not fighting it anymore and waiting for a work decision, and when that comes up, then proposing new law again or a new contract based on their decision? Is it within our purview?
It's common council. So the majority of the common council says, don't care what the state statute.
Well, that's not what I'm saying, because you said that it's an opinion and we're waiting on a decision from which will be appealed probably either way.
I'm not sure.
So the city council, can the city council say, settle this immediately, sign the contract, or order the mayor to sign the contract if you want to sign it?
Well, it's not just the mayor signs contracts. Well, everybody in the finance and personnel committee, the human resources.
Well, but we can order them to do that, can't we?
Well, I suppose the majority of the common council could say, sign a contract based upon the tentative agreement that exists. That's the negotiated contract.
Is that different than what is before it work now? Or what you said it specifically. So what I'm thinking, or what I'm trying to understand is, we're trying to settle this for retirement benefits and the benefits that we get. You said that we're actually not prohibiting those retirement, we're giving it to them, it's just not a signed contract, right?
Right.
Okay.
Retired benefits for, the right to health insurance for retired police officers and firefighters exists in the employee.
Is that the prime objection to the current legislation that's being discussed?
I think that, my understanding is that it should be in the contract and not in an employee handbook, but also that they want premium share for retired employees.
And that's based on the contract that was proposed that we're arguing against?
When I have gotten an unsigned draft proposed contract from RPA, from WPPA, it has included all the former health insurance language and the premium share language for retirees. That's what has been given to us, that they say, this is what we want this side.
So the majority of it is for the retirees? As
Or
opposed to what they get now with
like
salary and benefits and that kind of thing?
Yeah.
Okay, so if a majority of the common council decides to bring this forward and say, settle this now, is it within their purview to order that done?
Well, the common council has already approved the tentative agreement, the negotiated contract with that specific language. I suppose the common council could direct the bargaining team to go back and re-bargain that contract with respect to those provisions.
No, that's not what I'm asking. So we want rebargaining, we want to settle with the way it is. Or, I'm saying, if we want to settle the way it is, I'm talking to myself, of course. But if we want to settle with a proposal, we don't want to rebargain it, we want it done. We want it done, we want it out of support. We want the police officers to recognize that the city supports them. Now, as a retired police officer myself, after 20 years, and 20 years in the private sector as a security officer, I was the one that sponsored, if you would recall, the legislation for the therapists. Alderman Caprellian brought that up. And it's because it's really a stressful job, and you carry it with you as you go on. I still have, not as much now because it's been over 20 years, but I have nightmares of headless people that I found, kids that I tried to resuscitate that died in my hands. And I think about that and it still affects me. And so I think healthcare is really important, not just the psychological part of it, but, you know, you have shift work. You have, you don't eat well because you don't have time. I used to answer 14 calls in 8 hours when I was in Miami. If I could run through a drive-through at the time, I did, but otherwise, you don't do it. So my concern is that we're elongating this unnecessarily, as has been some of the comments that have been made here. We can definitely wait for a decision and move forward once that decision comes up, but we need to settle this. I have been told by police officers on the street that, hey, we're thinking of all leaving again. You know, we're down to 30 officers on the street, we only have 70 because the rest are, the specialized units are doing something else, or in training. And I'm thinking, man, we have shootings almost every night. We need to have law enforcement available, not saying, I'm not gonna put 100% effort here because there's nothing in it for me, even though that could be wrong, right? And you know that, sir, you're a military officer, you know the officers, you know the people that work for you would put in what they needed to do sometimes, not necessarily 100%. I see that if they don't feel that we don't have their back for the, you know, the current terms that, you know, we back the police. And that's what's going on now. And it's been going on for half a decade since that was already done. I remember that because I commented about it several times. I've commented about it in the media. We need to show the community that we care about the community. We need to show the community, in the police department and the fire department, that we care for them because of the
They say, well, it's like any other job. No, it's not. Neither one of them is like any other job here. You know, we have people that sit in their office, they, you know, maybe collect trash. We've had one trash collector who was run over by a car, we get that, you know. And there's risks there involved too, but it's not like every day where you never know. I used to kiss my sons and my wife every morning or every night before I went to work, because I never knew if they'd ever see me again. And I'm talking Miami. I've lost half a dozen people that were my friends, some that I trained as an FTO, and some FTOs that trained me, and some very good friends. And I know, Pete, I may be going off a little bit, but
Okay.
I'm trying to make a point here. We need to show them support, and if it is within our purview, I would recommend that the committee consider proposing that, and just put a stop to what could be something that could be going on forever. We need this settled now so that we can move forward.
I think,
Please.
can I interject?
Yeah,
Okay.
go ahead with yours.
So, with that being said, just to kind of piggyback off of, Alder Perez, it's evident and has been for some time that the cost is not just fiscal. It's taking a toll on our city, it's taking a toll on the two departments. So, with that, I'm gonna make a motion, to have the November 11th RPA version of that tentative agreement signed and forwarded to the clerk for the next Finance Committee meeting on March 10th.
November 11th, what year?
We received one in 2020.
For what purpose?
Well, he instructed that the Finance Committee is the one that has to finalize the signatures so it can go to council, because I re-listened to the meeting last night, from Monday night. So this is the direction it needs to take, so it can come before council. I talked to the WERC today about what I had heard on Monday, and they said there isn't anything that has been waiting for 15 months. They don't have anything. So, I need a second.
So you're making
I just made a motion, and we have a second.
No, let's back up, okay. You're making a motion to send it to,
To send the November 11th
back to
tentative
finance.
agreement version from RPA to the Finance
Okay.
Committee.
Gotcha. That was my,
Okay? And we have a
we
second.
have a motion on this. Any discussion?
Mr.
Alder-
Chairman, can
Yes, please.
this item is before this committee for an update, for action. And only the Finance and Personnel Committee can direct collective bargaining.
It has
Committee.
a communication attached to it.
This committee could refer this back to Finance and Personnel Committee, although the language of the communication is requested update. But it could request, or there could be a communication requesting that the Finance and Personnel Committee direct this particular
Would
action.
you like to change the wording to request that it goes back to F&?
We better get a clarification though, because I think what was just said, as seconder, and I'd be happy to do this, is if it were a referral, however, it only is referred on an update. So it would be better purposed by putting it through as a communication to go, rather than referring it back, because if it's referred back, they can't do any action on a discussion.
Right, I think the wording of this communication wouldn't permit action. It'd have to be a specific communication asking for action to be taken.
Good word, matter.
Yeah, right.
Word matter, no.
Yep.
So with that, I think it's a.
Aren't we talking about, the common council had already approved this. So I don't really, I'm unclear on what the intent is of referring something to finance and personnel that the common council has already approved on March 21st, 2023. So I'm just unclear.
Well, tentative agreement is just that. So there has been the tentative agreement going back and forth with the language. So I'm going to set up a communication right now to to have this referred to the finance committee, because you guys made it very clear on Monday night that that's the direction, if the council decided that, we as a legislative body, that that's where it needs to go.
So the communication needs to be received and filed, the discussion that we just had would have
Yeah.
to be received and filed, and another no other motion, another communication will have to come before the council before noon on Thursday. Was that, yeah.
So would the maker of the last motion rescind their motion? I'm sorry? Okay, you've rescinded that. Okay. Then,
Was the improper motion, so I moved to receive and file.
is there a second? Any further objection on receiving and file?
Just a
The update.
discussion point.
Any discussion?
No, I think, you know, even though these discussions can be uncomfortable and, you know, I think that we need to have these discussions. And, I think for clarification, is a receive and file doesn't necessarily mean that we don't want continual action. And I know it's not that your office hasn't been working on this, it's just now hearing a directive, you have a perspective, we have a perspective as well. I think to clarify what makes this different is we're saying we don't want to wait for the WERC's opinion. Act right now, the WERC, if they end up having an opinion a month, 6 months, whatever from now, then let's change course. Let's then go upon whatever comes before us that's new language. But, we need to work with what we're with right at this very moment. And, so that's to me a very clear difference in approaches. So, the receive and file isn't just to throw this away. It is to say, let's just keep moving and with this communication. But, you know, I appreciate this is uncomfortable. You've mentioned you're stepping in a position that you don't like to necessarily be here publicly having to do this. And I can say that for myself, sitting on this council. I've been having to speak in ways that are completely outside of where I want to be. That's, you know, I function in a completely different level, but I'm put in positions to now have to stand up in areas that I typically don't need to be. But here we are. We're dealing with city business. This is what's very important right now. And I challenge that, you know, this definitely isn't just a fiscal consequence. You know, I believe that there's so much damage that's happened in the last 5 years plus, and we need to heal. We need to just say, even if we're, you know, bringing this before all these committees, we're talking about it. And it's important, and so, you know, in all of these words, there's a thank you, and then it says we still have to keep being uncomfortable for a minute.
I would like to say thank you, Attorney Litney, for the presentation. I think you pretty much obviously answered all the questions that we have, so we appreciate it. I just had one question. How much time or years is actually left on the current contract?
Well,
Curious. No, but I mean, if there was one, how much time would be?
Even though it's signed today, it's already expired at the end of last year.
They won't sign it.
Okay.
So-
Yes, sir.
But they
And you mentioned, and you guys are very thankful of his presentation. Is there a venue or a stage where we can now present our opinion? We heard, Attorney Letney's, his opinion on this law and all that. Do we have a venue where we can present our opinion to you folks?
I would say that, yes, we could put it on you could talk to the clerk's office, put it on the agenda just like this one was, sure.
We would very much appreciate it.
Not a problem. Our next meeting would be 2 weeks from now.
Can I
Yes,
back everyone up just for
thank
1
you.
second? Okay. You want to put a communication in, you would need to get an alder or mayor sponsor. You could talk to one of the alders, they would request the communication to come to the clerk's office, and then we would work on that.
All right,
part of
we'll
it.
sponsor.
My other thing is, are we still in discussion, or can we?
We're getting ready to do that, yes. Okay, we have a motion. Is there a motion to receive and file?
It's been motioned.
Motion and a second. Any further discussion? Being none, all those in favor, please say aye. Aye. Motion carries. Again, thank you. And,
Can I make the committee aware that I will not be at the next PSL? I'm out of town from the fifth to the 15th.
Thank you
You know.
for the update. Okay.
You're not leaving, are you, Scott?
No, I know you want me to talk about other stuff.
Okay, so that, with due respect, to the chief, we're gonna take up the food truck item next, whenever you're ready at the clerk's office. Item number 089624.
All right, 089624, communication sponsored by Mayor Mason to adopt
Thank you,
ordinance
Chief.
0007-24, mobile food establishment hours. Recommendation of the PSL on 1/15/25 to be approved. Recommendation of the Common Council on 1/21/25 that it is referred back to the Public Safety and Licensing Committee.
Thank you, Chief Ramirez. Come and speak on the item. I'll let you proceed.
Good evening, and thank you for having me, thank you for hearing me out. This is something that's been hanging around for a while, talked to the alders, and, now we've got, hopefully have concluded, we've got now something, we don't have a mobile food truck ordinance at all. So this is maybe start to piecemeal it together here, and it's start with the hours of operation. Well, let me just back up here. The basic mission of the police is to prevent crime and disorder. The last several years, even prior to me getting here, we've had a number of areas throughout the town, and you heard some of the folks here earlier tonight, about the gatherings that happen, and the disorderly behavior, the shots fired, things of that nature. And I guess our true test of this is the absence of crime and disorder. That's what we do, that's our mission. And public safety is my number one priority. That is what I have to do here, contend with the citizens of Racine. We want to make Racine safe, and we want people to invest in Racine. Right, after a few meetings and the result of the January 21st Common Council, this item was referred back to committee in front of you guys here, and prior to that, I, along with a number of food truck owners, along with Director of Community Safety and the Chair of the Public Safety and License Committee, Alder Pete, we met in my office. All were invited. We have 14 owners, all were invited. Small percentages showed up, 4 of them showed up, but some of them owned two trucks or more. So we have a total of 17 trucks in the city, 14 owners. We discussed public safety, disorderly behavior, but the new ordinance in regards to nuisance, that mobile food establishments are now part of that they have to be responsible for what happens outside. Let me back up here for a second. I just want to say that I want people to thrive in this city. I really do. I think having food trucks, I use them myself, are a good thing. It brings people into certain areas that they normally won't be. They go to areas, they go to specific ones because they like the product that they have. But after much discussion, one of the things we came down and agreed to were the hours of operation. That's what we agreed to, and the hours of operations will be from 6 a.m. to 1 a.m. And that's what I'm proposing to you. We reviewed, I've got a number of calls for service that we've had at 6th and Park and at 7th and Park that caused a lot of this to come forward. 65% of those calls, disorderly behavior, shots fired, double shooting, quality of life violations came from 6th and Park. 7th and Park, 6% of those calls came after midnight. Again, quality of life violations. And all these calls could be deemed a nuisance and attributed to these food trucks. But I would like to stop that behavior or put some control of some sort instead of having a 24-hour operation of food trucks.
Yes.
So that you met with the vendors,
I did.
and because they wanted to stretch out the hours, and are they amenable to the 1 o'clock?
We agreed to, as witnessed by all the.
Yep, they did.
And for 1 o'clock, the one they operated on 24 hours, most of the time he was at first, but then he agreed to it. I think we can work with it. We can review it a year later from now.
Perfect.
Yeah.
We're not the only city that has restricted hours. Milwaukee has a 3-tier system, restricted hours.
Yep.
Kenosha has restricted hours. So I'm proposing that we,
You know what the hours are in Kenosha?
Kenosha's, they stop at 8 o'clock at night.
Oh.
Yeah.
weren't too bad. We started with 10.
Milwaukee goes
So then the guy from Kenosha come here,
to what?
from 8 to 1.
Yeah, you can do that.
Well, if,
You have a, I have a question.
Yes, Oliver.
Well, no, I think it was.
yeah, go ahead.
No,
Well, okay.
not a question really. This has been, this ordinance thing's been going on for years, trying to get something hammered out. I go to different places at night when I see these. You'd never be able to get a handle on anything for food truck ordinances, downtown, anything what we've tried to do. And the hours, to me, has been the most critical thing. There's been so many problems with some of these vendors, and it's not the trucks, it's the people that come to these. And we need to put some teeth into something and do something about it. People say something like, well, we're a food desert. Well, do you have to go out to a food truck at 4 or 5 o'clock in the morning? No.
Probably not.
I mean, I think we need to, I thought midnight was a good time, but I'm amenable to 1 AM. So I just thank you guys for having us meet with them.
And I thought it was important to meet with them because it gave them a voice too.
And I would add that, as the chief said, I was there, and the vendors that did show up were fine with the hours, had no problem, except, as he said, one person. But everybody was in agreement by the time we ended. Yes, sir.
I got one more question. So in here, so for nothing for after hours anymore, am I correct? So that's deleted out of here? All right, I would make a motion that that part be deleted right now. It's recommendation of the Public Safety Licensing Committee on 10/9/24 that the ordinance be deferred to be amended to include a permit fee for after hours, but after hearing this discussion, I wanna delete that.
That's correct.
I make a motion to delete that section of it.
Second.
So,
Just a second, Attorney Munoz, please.
so that's just a recommendation of the committee on that date?
Oh, so we don't have,
It's not
okay.
part of this ordinance.
Okay.
The ordinance before you prohibits food trucks from operating between the hours of midnight and 6 AM. So if you wanted to approve the chief's recommendation, you would
Okay.
just have to make a motion to approve the ordinance with the amendment that the hours be changed from midnight till 1 AM. I can make those changes and get it to you.
Okay, I would make that motion.
Should I have a second? Any further discussion? All, if seeing none, all those in favor, please say aye.
Alderman Cassidy, have a question, or?
I did, but that was just on the amendment.
Yeah, and
That
she,
was, right?
yeah, right,
Yeah,
that was taken
just,
out.
amendment.
Okay,
So I'm good, thank you. But I do have one, yes.
okay.
Oh, am I
We
ready?
just hit-
Okay. So, chief. So back when this got brought up, I had deferred it to allow some time for investigation, but I believe at that same meeting, we were approving, an extension of the nuisance ordinance as well, right? There was talk about the nuisance ordinance now expanding, right? So is that in effect? Is that been?
That was during the budget hearing, if I recall correctly. It's in effect of January 1.
Yeah, it was,
No.
That
The
food
nuisance-
establishments would include,
Yeah.
yeah.
mobile food
The
establishments.
definition of what can be a nuisance establishment was expanded to.
Yeah,
Mobile
back in
business.
November.
Yeah.
Yeah, previously you had to be a brick border
Yeah.
in order to be a nuisance. It was just sort of a gap in our ordinances.
Yeah,
So now that's been cleaned up,
back
which
in
is great.
November.
And I think that's perfect, you're right, because I believe then that is more targeting, because it was just stated and confirmed that the issues are not the trucks, it's the patrons
Yeah.
that are coming, right? And so I'm still having heartburn. I'm glad all these steps are going. I've been able to talk to the food trucks in the interim of all these deferments before it comes back before it. I know that you've met. And, but I expect you to come before us and state exactly what you're saying, right? You come before us, you're saying there's this public safety concern, and, I remember when Dottie Case came before us, and I expect from the health department that this would be her argument. She wanted to, an all-city ban on smoking in public parks or public places. I would expect that out of the health department. I expect this out of you. So here's the balance, right? So, I believe that the problem is not the trucks. And now we are equipped with this extension of this nuisance ordinance that can now be enacted upon the patrons, upon the problems that occur at these food trucks, if they hold some level of responsibility to that. Because I think what was brought before us to this committee was they were leaving waste behind and grease and, whatever else that would trigger responsibility. Now we have something, a tool in our toolbox to be able to use to actually punish or bring attention to the problem.
Help change behavior.
For sure. I just believe, we're seeing, we bring forth many things. We're trying to make ourselves attractive. And I think we offer different, right, whether it's the little scooters that we're bringing into our community or different things to try to attract different populace of people. And so I think there's an economic lens to take a look at this. There's an attraction lens, and I think there's a community needs lens, with our second shift or third shift. I know a little bit something about food deserts, so I would probably speak a little bit differently on it, just being as the previous executive director of a food bank. But I just think that we need to focus where the problem is. If we are having a gathering of rowdy people, I'm sure you have policies or actions in place, procedures in place to deal with those situations. To restrict a food truck, I think one public commenter had stated, him serving a hamburger and somebody eating a hamburger, that's, nobody says, oh, I want to get out there and now, ruffle up somebody, right, from eating that hamburger. So I'm in a position, I understand you guys all came up with an agreement, this 1 o'clock being agreed upon by a couple of you, the food trucks and the public safety and the alder here. And I respect that, but I think I'm going to be in the minority and state that I don't agree with it. I don't believe in that restriction. I think the restrictions more so need to be about their placement in front of other restaurant as food establishments. And that wasn't addressed in here. Is that because we didn't direct that, or should we have direct that where a food truck can't park within 50 feet of another restaurant?
So initially, this came before the committee as a discussion. I believe you were not at that meeting. The discussion was had, the committee decided to move forward in a different direction. That item was received in file, and then this ordinance came about as a result of a sponsorship request. So certainly you could direct another ordinance, sponsor another ordinance to address the other aspects of food regulation, food truck regulation, but this ordinance is.
Thank you. So I guess just give you a brief summary of my position, although you probably say you don't need it, but
So we're here.
Oh, thank you. This is a food truck, right? They're not going around and they're handing out liquor, right? And they're not handing out this privileged substance that has this ultimate this consequence, huge consequence to the end of it. It's the food truck. And so I just don't think this matches. It doesn't pair well in my mind for this restriction paired with a food truck. If it was a liquor truck, I'm all for it, right? It makes sense. So.
I think yes.
5, 6 years ago, when all these food truck things were coming forward, we tried to get, because the people with brick and mortar stores were upset that trucks were parking in front of their establishments. They could not come up with any agreement, and it just died. I mean, to me, this is a really good start, and then move forward with other ones, but we need to do something before the warm weather gets here. Andy wants to.
I'm gonna weigh in, I'm gonna go back farther than 6 or 7 years, I'm gonna go back almost 24 years. One of my first actions when I first got elected in 2000 was Bonnie Kidwell, who had 4 shows at her house where she would make primitive crafts, and she would have 4 shows where she would sell stuff. Rick Heller, who was at that time the chief building inspector, shut her down because you were not allowed to have 4 rummage sales, what he called rummage sales or craft shows in your house. You could only have 2 per year. So we had to change the ordinance to accommodate what she did. And the argument against what she was doing was because she was competing with brick and mortar stores. And the same argument can be made now for the food trucks. So times change and people's tastes change. And it's sad to me that people need to even go to a food truck at 1 o'clock, 2 o'clock, 3 o'clock in the morning. It's sad to me that they would have to do that. But I do understand from a safety perspective that just like we hold bar owners responsible for the actions of the people that frequent their bar, we do have to put some kind of regulation on the food trucks. So if everybody is amenable to the 1 o'clock, I'm
Okay,
amenable to
I
it
think
too.
I have a motion.
Yeah, I know
A
it's
motion
second.
and a second. Any further discussion?
I do.
Okay.
I've heard now from, there's 3 others who have talked about, just about the location restriction or lack thereof, about placement or competition. And so do expect in the near future, I do think that is a warranted, item to be bringing before for consideration. As you know, I'm going to be voting down this approval, or I'll be not in agreement of this motion to approve. I do understand that there is a level of responsibility with the liquor establishment, but I see a difference. I see a clear difference in my mind of a liquor establishment and them being responsible for their patrons if you're giving out liquor. But I just don't see it with food.
Seeing no further discussion, all those in favor, please say aye.
Aye.
Aye. Okay, we have an opposed? I guess. Okay, motion carries then.
Thank
So
you.
this can
Thank
come
you.
back.
Yeah, it
to
can
amend.
make,
Yeah,
you
this
can make
come back to
changes,
amend
that's
to-
not
to
an
address
issue.
the Alderman's concerns.
Thank you for
Thank
coming
you,
back so
sir.
many times, Chief.
Thank you. At least you have something to
Thanks
work
for
on
having that
now.
conversation with them, so.
I anticipated, because you would ask that question.
Good. I'm learning.
Another thing I want to bring up sometime is that we should be able to throw candy from floats at parades.
I
All
agree.
right. I will point out, even though we're done,
I was on the
that
fourth,
the
boy,
ordinance,
good luck with
the
that.
ordinance is set up
No
so
silly
that,
putty or no-
say, I'm at this location, and
I don't think I need it for any other item.
location problem,
Yeah.
provisions already there, so after 6 months, the guy can say, I need to go to another
All right.
location,
All right.
and as long as
Get-
he's not a nuisance,
Go ahead.
then he's fine, so.
Going back to page 1.
010745, I know, I just wanna make sure.
0725, communication sponsored by Alderman Widener, requesting to review violation of ordinance 2-206 and 2-207 regarding lack of mayoral appointment and council confirmation of members to the Civic Center Commission.
Alder Widener, would you care to
Oh,
speak
I
to your
would,
motion?
But would the attorney mind coming up so we can kind of have a conversation? Because I want to be as brief as possible, we've already been at this for 2.5 hours, so
Thank you.
I want to be mindful
We
of that.
appreciate
And I know
that.
the staff want to get home. So I'll preface what I'm saying, that I was surprised when I came back to council how many fewer committees, boards, and commissions there were. And my concern has always been to have honest, open, transparent government. And the less public input we have, the less open, honest, and transparent I believe that we are. So one of the things that I noticed was that the Civic Center Commission had not met since 2019, although we do have a statute, do have a statute, 2-206, that is very clear in that the mayor would make these appointments, hold on. I tried to fix this so it didn't go out so quick. So 2-206 was created in regards to the Civic Center, and it says, there is hereby created a Civic Center Commission as provided in this section. The members therefore shall be appointed by the mayor subject to confirmation of common council. Then it goes on to say what the members consist of. I have a great concern that there has been no Civic Center Commission, no members appointed to that commission since 2019. Doing a little bit more research, I see that it doesn't excuse no appointment for all that time, but I do see that in February 26th of 2024, when the new contract was negotiated with the city administrator at that time, Paul Bornholt, that he kind of changed things. So what it says to the Finance and Personnel Committee is that oversight will be changed to the Board of Park, Recreation, Cultural Service. Previous oversight was with the city administrator. I don't know who ever approved that because we still have the ordinance on the books. So we kind of have a dichotomy here, Scott, and that's really what I wanted to, talk to you about. Do we just allow the mayor to, in my view, neglect his responsibility in appointing members of the committee because he felt that he or the city administrator or the Parks Board would be better at supervising? So do we try to enforce the ordinance, or do we try to remove the ordinance to come in compliance with this new memorandum?
I feel like this is one of these questions I can't answer in any way at all.
Sure you can.
Well, there's been 5 mayors since I've been in the city, and mayors do what mayors do. I can't speak to why there weren't any appointments. I have no information. I have no information. I can't speak to that. A possibility would be, like has happened with a couple of other commissions or authorities along the way that have been consolidated. There have been a number of consolidations in the past 7 or 8 years of bodies, and it could be that whatever the duties of the Civic Center Commission are by ordinance be consolidated with, for example,
What bothers me there is that prior to 2019, the Parks Board met every month, faithfully. And going from 22, 23, 24, or excuse me, even 21, sometimes that board meets 4 times a year, sometimes 5, sometimes 6. And part of the problem there is the board has vacancies. So the mayor has failed to appoint to that board. And also when I looked at over the 21, 22, 23 at the Parks Board, there had been nothing that had been provided to the Civic Center Commission prior to 2019, no financial reports, nothing has been provided to the Board of Health, the Parks Board. So, and it was the same thing with the Cemetery Commission. When we had a Cemetery Commission, we met monthly, and, reports were filed, and all that is gone. So the council is getting less and less information. The only thing they really can do is approve a budget. So if the mayor fails to appoint, is there another avenue that can be taken so that council president or the council, or you can't just ignore the ordinance?
I understand everything you're saying. There is nothing in the ordinance that would contemplate anybody other than the mayor making the appointment. Any of the existing commissions, commissions, boards, or authorities.
So then we're going to be discussing another change in the ordinance and the next item. So would the appropriate thing be for this, for communication to be submitted with an amendment to it's not just this board. Somehow somehow we have to have the public involved, as they had been prior to this mayor. And I don't know how to, I guess a tougher question would be, if the mayor fails to perform his duties, is that malfeasance or official misconduct?
I don't believe there is a procedure other than recalls for, removing a mayor from office. Elected officials are different than appointed officials. There is a procedure for the common council to remove other alders for neglected duties, but not, the mayor, so.
Well, maybe I'm not understanding this statute right, that says Wisconsin statute section 17.16 would require the filing of written charges by a resident taxpayer at a public hearing before the common council, for an elected official.
I'd have to look at that, ma'am.
Yeah.
I'm sorry,
Yeah, that's okay.
I'm aware of that statute. I didn't read it in preparation.
Okay. Yep. So, I can't force the mayor to appoint. I think it's very important that we have a civic center commission, or if we're not gonna have a civic center commission, that the council agrees to remove these ordinances, which I think would be foolhardy.
We're in a pickle too.
I do gotta say, it was a good board, but because by this ordinance, I was the alderman and I had to be on there. And we had a lot of people down there that did stuff for the festivals and stuff like that, that had offered a lot of input. And all of that is gone. And I think that would help them down there immensely if they had some of that. I don't know
So,
what we can do to get
What are-
this moving.
what are our options? Can we change the ordinance in which someone other than the mayor can appoint to committees?
Yes, well, let me just back up. There are some that are required by state statute.
Okay.
And that are require, mayoral appointments specifically by state law. Those, no, the common council, that do.
I don't think.
This is not one that's required by state law.
So perhaps we should receive and file this at this point and take this item up in the next item that we're discussing, where we're making other changes to the standing committees.
So,
May I ask a question?
yes,
Okay. Are you able to put a communication into, let's say you had people approach you that wanted to be a part of the committee? Could you put a communication in to say person X and person O would like to serve on said committee that is currently just sitting dormant?
I think you could do as far as you've said, but there's nothing in the ordinances that would say, and then that person is appointed to that.
There currently is a list of those interested in serving on boards and committees that is provided by the clerk's office to us. So I'm sure some are on that list to serve on there already.
Oh.
Okay.
Find that list.
And those people aren't being appointed?
Not sure that
Part of that, I can find that list.
I just looked at the list today. The last time I looked at it was probably about 2 months ago, and of the 19 commissions, boards, and commission that currently exist in the city of Racine, we had 53 vacancies. And I personally have talked to 2 people, the second one who submitted 2 applications to serve on a board, commission, or commission that had a vacancy, and they received that bump out email that said, "Thank you for your interest, we'll let you know." So there are people that are interested in serving on these boards, they're just not getting tapped. And, you know, having this discussion, you know, I'm gonna say right now, the way it stands now with the way the mayor appoints to the city boards, commission, committees, he neglects 2/3 of the council. We have 3 aldermen that serve on multiple commissions, and then we have the vast majority of the council that only gets appointed to one committee. And I've never witnessed this before. I know elections have consequences, I know that, but I have never, with the 5 mayors that I've served with, I've never experienced this before where such a small circle of not only aldermen, but also the public are being allowed to serve their city. And I just don't think it's healthy for our city. So with that, I guess I'll receive and file this communication, maybe kind of take it up in the next ordinance when we're discussing changing the standing committees, because there were some other changes in that kind of relate.
Second.
Okay, any further discussion? All those in favor, please say aye.
Aye.
Opposed? Thank you. Next item.
Next item is 016625, communications sponsored by Alder Capillion and Alderman Widener, presenting ordinance 0001-25, common council community structure, recommendation by Alder Capillion and Alderman Widener to go to the Public Safety and Licensing Committee. Staff recommendation was to go to the Executive Committee, and recommendation of the Common Council was that it come back to the Public Safety and Licensing Committee.
So you ladies have the alders?
I can speak on it. So what you have before you, with this ordinance, change is, I think, fundamentally protecting our, democratic process of government with our balanced government. And we have found, since we tried to reinstate the powers of the legislative body back by giving us control of our agendas, we have found that there's some other snafus or things that are catching along the way. And we have seen since Corey Mason's position as mayor, as we just witnessed from our last communication, this, in a sense, this erosion of the council's authority, or the legislative body's authority. This ordinance that you have before you this evening is to restore, in essence, the balance of the power that our city government requires to function properly. So it's not asking for anything extraordinary. It's just really to establish the balance of power within our local government here. It's not about personalities or politics per se. It's about perceiving the fundamental principles of our local democracy. And so the changes proposed by transferring committee appointments as part of it, by transferring our committee appointment powers from the mayor to our council president, we ensure that our legislative branch can organize itself independently. And by removing the mayor ex officio status, which is another part of this, on all of our committees, we maintain a proper separation between our branches. And then formalizing the committee of the whole as a standing committee, we essentially allow for council deliberation as a whole body, where things tend to not necessarily fit standing committees, but it would fit in more appropriately with the full council body. I do have a lot more to say, and especially with just the historical processes that we had in place prior to this mayor coming in. And I can go into that a little bit, but I think it's more so, this is about just, we can remove, I guess, that, my statements about that, and just realize this is really about balanced government. And it's nothing out of the ordinary. So if some of these may seem like, this is like I've been hearing this personal attack on the administration, when I would argue this is about a principled stance that many other municipalities follow, and they follow it for reasons. And I have a list for many other municipalities, but I would like to hear the discussions of the committee to be able to direct my next points to highlight.
I will start. I've heard people say they worked with five other mayors. Could you clarify that? Did you say the other 5 mayors? Because, first of all, we're really talking about,
The longevity is that way.
well, yeah,
That's
but,
5 mayors.
okay. Oh, yeah. But anyway, we're talking about a shift of administrative authority, a shift of power, if you will, what have you. So did the other, in 205 or 206, 20 years or so, was the structure of the council set up the way this ordinance changes before you?
No, I don't think so. Maybe we should go into the specific changes. It's in your packet.
Yes, I've seen
We're
it.
we're in ordinance 0001-25. And this ordinance is to amend Chapter 2, Article 2, Division 3, 4, and 5 of the Municipal Code of the City of Racine. We're amending in Part 1, we're amending the time from 7 p.m. shall be deleted and the time 6 p.m. shall be substituted because...
Yeah, we already did.
When the council changed, I'm sorry.
Yep.
Sorry to chime in.
Yep.
When the council changed its regular meetings from 7 o'clock to 6 o'clock, we failed to change the time for the organizational meeting, which is the first meeting of the new council.
Okay.
The ordinance still says 7 o'clock for that one. This would just bring this into line with the rest of it.
Okay, makes sense.
It's just a cleanup provision.
Sure, okay.
So then Chapter 2, Article 2, Scott, is the municipal code in which we elect a president at the first meeting. And
Yeah.
what we're proposing is that we also elect a vice president to act in the place of the president should...
So the president obviously calls the committee of the whole meetings and serves on the executive committee. The president also chairs the common council meetings if the mayor is not present. Right now, if both the mayor and the president are not available at a common council meeting, then the common council elects one of its members as chair pro tem for that common council meeting. This would just add a vice president of the common council, and I guess in theory, if the mayor, the president, and the vice president were not there, then council elects chair pro tem for that meeting, but simply, there would be no other responsibilities for the vice president except to act if the president were not able to act.
And recall that happened during budget
Yep.
time when...
Yep.
So, and I also think it will give other aldermen who have been shoved off to the side, an opportunity to serve in another capacity, which I think is important for all aldermen, because as I say all the time on the council floor, there are 15 aldermen, we're all equal. And we're all qualified to serve as president. Now we're qualified to serve as vice president, we're qualified to serve as chair or vice chair of any standing committees. If those opportunities are denied to the majority of the council, then this would give the council the opportunity to offer that kind of opportunity to one of our colleagues on the council. And it also would be our pick, which I think is very important. So that was the other change. So we would be electing both a president and a vice president.
Part 3 just indicates that the vice president would be elected pursuant to the same procedures as the president following the president's
Correct.
election.
And then
And then Part 4 just talks about chairing the council meetings in the case the mayor and or vice president are up there.
and then Part 5, Scott, you want to speak to that?
That Part 5 is the provision that would, Part 5 would change how standing committees are appointed. So the first sentence is, except for the committee of the whole, which shall be comprised of all aldermanic members of the Common Council, all standing committees shall be appointed by the president of the Common Council annually at the organizational meeting of the Common Council. And I just note in the agenda briefing memorandum, there's some underlined and striped through so you can see what the ordinance would look like after written. So that's the change. It recognizes that the committee of the whole is all alders, and it would change from the mayor to the president of the Common Council appointing committee members.
So that's the other change that we're proposing, which is a big change.
Yeah.
That's a big change. So then, chapter 6.
Part 6 would just add, committee of the whole as one of the list of standing.
Yeah.
And that would be chaired by the council president and the vice chair. And just to speak to that a little, is you recall when the committee of the whole, which is the council, made ordinance changes, it took 2 months for the mayor to now declare that ordinance changes have to go to a standing committee, and that did not take place for 2 months. So because the Common Council really should be a standing committee, just trying to codify that. So then that changes several different sections of the ordinance, correct?
Let me just go on.
Yep.
The next provision, part 7, would change section 2-79. Right now, that ordinance says the alder is first named on a standing committee is the chair, and then the next one is the vice chair. It just clarifies that this particular section wouldn't apply to the committee of the whole or the executive committee, that have, of course, their own procedures. But it would still indicate that the alder first named, by the way, it also, as we go through, we're trying to clean up gender language, so it says alderman everywhere and chairman, so it just would say alder rather than alderman. So it's alder first named on each standing committee, other than committee of the whole and executive committee, would be the chair. The alder next name would be vice chair, and then this additional provision that no alder may serve as chair or vice chair for more than 2 consecutive one-year terms. That's an added provision. The next, do you want me to just keep going, ma'am? Okay, the next one, part 8, would change, would actually repeal section 2-80. That's the provision that says the mayor is an ex officio member of all standing committees, so by virtue of being mayor, he's a member of the committees, or the mayor is a member of the committees, with all privileges of membership except the right to vote. So that would just be deleted. So the provision that has the mayor being ex officio member of all standing committees would just not exist. The next one, section, part 9, that's the section that relates to when meetings of standing committees are held. So it generally says it's the week before Common Council meetings. It just adds a provision that recognizes the committee of the whole meets at the call of the president of the Common Council. So just an exception to that. And then the last section, which is 10, in part recognizes that the committee of the whole would be a standing committee, so that proposed ordinance changes could go to the committee of the whole, but also proposed changes to the ordinance could be directed to the committee of the whole through communication, or could be referred to the committee of the whole by another standing committee or by the Common Council. That would just be a path for ordinances. And that is.
And there's nowhere in here I can add, Scott, that when the mayor fails to appoint to the other city boards, commissions, committees, that could be done by council president or.
That could be a change. I would just note that these particular, not that necessarily couldn't be changed, but these particular ordinance changes relate to committees, which are subunits of the common council, and none of the other boards, authorities, or commissions are subunits of the common council. So in a different portion of the ordinances, but certainly that change could be made if that's what,
I don't wanna muddy this up, just leave it as is. All right. I like it, thank you. That's my discussion.
Any other questions?
I think I'll make a motion to approve.
Second.
Any further discussion? All those,
Tired, but.
all those in favor, yeah. I asked if there's any other questions, discussion.
No, I'm
Okay.
happy with this.
Okay.
Is everybody else?
Okay.
It's very deep. Scott did a great job explaining all of it, so I
Yeah, and then-
Well, I would say, for discussion, I would say that I think the whole body should discuss it, the whole, 4 major changes in their entirety, because as you guys are saying, it does not affect the council and the community. So I don't think we should take it lightly. I think that we should really sit down and go through it and think about what does this new structure look like? And as opposed to just saying, okay, let's just pass it through. I think we owe it to the community as well as ourselves.
Well, I don't know about the community, but I can tell you
Well,
that.
transparency, of course.
This is a standing committee, an ordinance change has to come to a standing committee. If it is approved in the standing committee, it will go to the full council for a more robust or full-throated debate on the council floor.
Yeah.
But this takes it out of the mayor's hands to, at his will, finally call an executive committee. So it came to a standing committee, so
I
that
understand.
can have a full council.
I'm just talking about the changes themselves, the ordinance itself. Okay, we've already had, no, I don't want to kick it down the can, I just wanted to make sure everybody knows exactly what this looks like. Other than, as you guys have said several times, words do have meaning, you get that. Okay,
Well, I can tell you
I
that both the ordinance change and the agenda briefing memorandum that the city attorney created, which was very in detail, and many people read it before this came to this committee. And there was one or two that, the only concern that they had wasn't so much that the, committee of the whole would be a standing committee. They were more concerned about, the council president making appointments of chair and vice chair and appointments to the other standing committees. So that's the only one I can see getting some pushback on.
I would have some questions about that, too.
Well, it would certainly change the flavor of the executive committee if the executive committee members are chairs that are actually selected by the council. So that would change some things.
Yeah,
Um,
okay. Yes.
I know this is your first time serving on an elected body, your time serving here in the council, and, you being an alder. And I'm fortunate enough to be on another elected body, as you know, and who happens to have their chairman appoint the committee members, the standing committee members. And I just came back from Madison, and happened to be a discussion, and not so much led by me, but I had an interest in it. And so, what we present to you, this isn't like an oddity, it's not.
No, I
it's not
understand that from the
and-
state statute.
And just to make your point about you would like everybody to be in this robust discussion on the city council, that's exactly what's in this ordinance, because as it sits right now, we can't send things off to committee of the whole to have this ordinance reviewed. This makes it so where we can.
I understand.
And,
No,
so
I
we're-
understand, I just had some concerns about the intent themselves, not the just general understanding.
Well,
But
I feel like, yeah, I think the intensive care, this is one thing that longevity can do when you bring wisdom and historical knowledge. Some of us have just only grown up under certain leadership, so it's all what we know.
I understand.
And, you know, depending on what path, and some people surround themselves by a lot of diversity of other legislative bodies, and it tends to then bring a different perspective and a different path, and that is the beautiful thing about bringing forth diversity, is that you have different perspectives to offer and different things to chew on. And I just think there has been, this gradual weakening of the legislative body in our local, That's hilarious. Well, anyways, my point is, because of that gradual weakening, we need to strengthen our legislative power back up and balance our government. So I'm hoping that the alders, before it comes to council, that they would revisit their. You're welcome.
Okay. Press any key?
Any key, just press any key.
Okay,
Is that one of these?
No, there.
Okay.
No. All right, we've already, well, while we were still live, it was approved.
Go ahead.
Oh, we
Okay.
didn't, it was motion and second.
No, we had most of the second.
But we didn't vote on it.
Yes, you guys did.
Did not.
You need to vote on the item.
I thought you did, but okay.
Thanks for paying attention over there, Amber.
All right, you had a motion and a second.
Yeah.
Oh, I appreciate
All,
that.
all those in favor, please say aye.
Aye.
Opposed? Motion carries.